Mm, 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 mm. This one. 31 to 34. Case diary is received. Sure. On no, no, after the on 22nd, on 23rd, maybe. Um, 31, 32, 33, 34. Huh? You learned senior council did this. Um, six an adjournment um, due to his preoccupation with another ongoing appeal matter. Uh, list on 23. 2310. Interim order is there. The interim order granted shall stand extended till the next date of listing. 31, 32, 33, 34. 2310. Okay. Case diary you don't know, no, whether it has come. Okay. The name of P. Kotoki, learned standing counsel, learned public prosecutor, special PPCM vigilance cell may be reflected in the cause list. Kindly inform Mr. Kotoki. Huh? And you tell your junior. Not covered. 37. No, the CD not received. List after list on. This can also be 23. 2710. Interim order is there. Interim order granted by the order dated so and so stands extended till the next date of listing. Right. No new. Yeah. Okay. 43. Is diary not received? Issue reminder. List on 10/11. 10/11/2025. Interim order granted by order date itself stand extended till the next day. Oh, okay. 38. This learned petitioner council submits that. Okay, you are for the petitioner. You are for on our behalf. It is submitted on behalf of the learned amicus that due to bereavement, the matter may be adjourned today. Prayer is allowed. Interim order is there? No. List the matter on 20, 2710. No. CD received, be retained. Earlier rejected. No. Because in new matters you have to list before the senior bench, right? You make them a Mhm. Okay. 42 case diary not received. Issue reminder. Interim bail. Case standard date to mention extended list of the listing. Case diary to one I note. List on. He's on interim. 10/11. Item number 50. Item 50. 52. The service report upon respondent number 2 stated to be not yet received back. Full stop. Diary also not there, na? Diary, CD is receipt. So, he can, you can take instructions regarding service. Prosecution shall take instructions regarding the said service. Case diary receipt and be retained. Interim is there? No. List the matter on 23, 2310. Okay? Adidas, check the microphone. Microphone. It's a check. Yeah. Mhm.
Been filed, my lord.
We'll call for.
If my lord, if charge sheet is filed, then my lord, I may be given an opportunity to try before my lord, the jurisdictional trial court.
That's your
But my
choice.
lord, if my learned friend could confirm that, my lord.
Should we?
Yes, well, I will have to confirm because regarding filing of search sheet, my lord,
Then after some time, my lord, once he confirms, my lord,
Yeah, take it up in a normal course.
my lord, oblige.
May it please your lordship. Lordship, this is a regular bill. Probably lordship ought to come under hearing list, hearing column lordship, because earlier lordship has this item was listed on 19.9 lordship. Moreover, lordship office notes said lordship service has not completed lordship.
Okay, so
it is also not received.
the case diary is not received.
Already 66 days lordship. POCSO 6 is there lordship.
Case diary is not yet received. Issue reminder. The prosecution shall take instructions regarding service upon respond number 2.
And that will be come up for bail.
Yes.
Earlier, the city called for bail.
Already called for yes. Issue reminder. List the matter in the column of bail hearing on.
It's from Jhalukbari lordship.
24.
25, 25. Oblige.
If it's not a holiday, just check. 25 is a holiday.
Lordship.
Saturday, only fourth Saturday.
27 then.
27? 27:10.
Highly organized.
By page of lordship. Lordship, I have also similar prayer, my lord. In this case, earlier one occasion was listed, but today why?
Motion come by mistake.
But service is not completed, my lord. CD also will not received.
Issue reminder for the case diary. Okay, no. Prosecution shall take instructions for service. List the matter in the column of bail hearing on same day.
Same.
2810.
20,
28th.
my lord. Must.
May I please the lordship? Item number 3, 63 and 64 may be taken along with my lord. 63, Dada. 63 and 64 also.
Earlier rejected by your lordship. Mr.
Earlier rejected your lordship, second time.
This is okay. Sir. First
Second.
time it's come. No, first time it has come.
No, madam.
First time comes,
No, no,
second,
today the-
second bill application.
This yeah, that's okay. But today it has a second bail has been filed. Has
Lordship.
come first time.
Lordship, and in this case, my lord, in another case on 13/10, another case was listed, learned PP submitted that investigation is completed and charge sheet to be filed. On that ground, the said accused has been granted bail, my lord.
Case diary, that day case diary was not received, no? You just remove.
No, my lord.
No, it was received, I think. That day, I think case diary was received with that,
On
with
instruction
that
has been
intimation.
given.
Yes, yes.
I'm relying on Sanjoy Chandra, my lord. $75 today.
This was the instruction you had received. I remember you had received. investigation is completed and charge sheet prepared for vetting. You confirm it again. After some time, we'll take it
Yes,
together.
Lordship.
একেলগে দি দিব একেলগে পানী তো এইটো 63 64 হ'ব ন 63 64 We'll take it up after, let him confirm the instruction again. Call for the case diary. Call for the case diary of Mangaldoi PS case number 188 of 2025. The accused is stated to be in custody since 26/9/2025. List the matter on. Regular bill. 2810.
May it please your lordship. Lordship will recall, my lord, earlier one case I moved, my lord, of this person, my lord. Lordship had granted the interim, my lord, as for his surgery, my lord.
What's all that one?
That order, my lord.
Miss Roy. But this is another case.
Another case. That total there are 5 cases, my lord.
Hmm.
This is the 4th one, and tomorrow is another one, my lord.
Similar order SCP passed, no?
My lord.
এইটো ইয়াৰটো নিচিনাই আৰু। Can I keep this?
Yes, yes.
এইটো বেলেগ হ'ব facts. Case number. হাতীগাঁও PS case number 156 of 2025. হাতীগাঁও PS case number এইটো লতাশিল আছে এইটো হাতীগাঁও case number 156 of 2025. He is in custody since 8/10/2000. He was shown arrested in this case on
Yes.
8/10/2025. আপুনি মই মিলাই দিম বাৰু এইটো বস্তু এইটো অৰ্ডাৰ এটা 4 5
Here the allegation is, my lord, he failed to pay the pending installment of the car amounting to rupees 13 lakh
This
50
is
thousand.
slightly different. এইটো 5 টো নালাগে দেখোন এটা এইটো নালাগে 6 to where no again 30,000 with one cent.
I'm obliged.
Same conditions till 7/11.
Till 7th I will surrender, my lord.
Okay, what time?
I'm obliged.
অসুবিধা হ'লে মই দেখাই দিম No, not this process. Entered in 7/11. List on 7/11.
May please, your lordship. The regular bail application, lordship. Offense lordship under section 103, lordship, murder. And this is the second application preferred by the petitioners. And today, lordship, 69 days, lordship.
Let us see the updated CD.
Lordship.
We'll fix it next week. if
Yes.
possible. It is fairly submitted that the earlier bail petition was rejected on 17/9/2025 in connection with Kakopathar PS case number 43 of 25. The accused is in custody since 9/8/25. Call for the updated case diary list on 29/10.
Along with PM report,
Case diary along with PM report.
29. Could it be before that, lordship? 69 days today. Could be like Lordship. Obvious.
27. 2710.
Here the petitioner, my lord, is a lady, my lord. My lord, she is the wife of that Dharmeshwar Roy,
Yes,
my lord.
boss.
Your lordship will find the FIR at page 14, my lord.
Please, 14.
14, my lord, FIR. May I read, my lord? With reference to the subject cited above, I would like to inform you that via an agreement dated so and so, I purchased a vehicle noted below from the accused number 1 at rupees so and so. As per the terms and condition number 3, the said agreement, the accused person number 1 was supposed to clear all pending installment against the said vehicle to the finance company. And if she fails to do so, she will be liable as per the provision of the law. The accused person number 1 was also supposed to sign the necessary document for transferring the vehicle in my name as per the condition number 5 of the agreement. But surprisingly and mysteriously, the accused number 1, with the instigation and help of the accused number 2, husband of the accused number 1, had not paid any pending installment against the vehicle in spite of several requests made by me. The accused person have not also signed any document for transferring the vehicle in my name. Having no other alternatives, I have cleared the pending installment of rupees 13,50,000 against the said vehicle to the finance company. The accused person have thus committed cheating, fraud, and criminal breach of trust with me. After inquiry, I came to know that the accused person have cheated many persons in this modus operandi. So this is the case, my lord. In fact, my lord, if your lordship turns to page 19, my lord, that amount I have paid, my lord. Page 19, my lord, handwritten, my lord. We have purchased the Safari so and so, my lord, at a price of rupees 20 lakhs from Dharmeshwar Roy. We had paid a sum of rupees 15 lakhs only as the advance payment. My lord, this is a receipt, my lord, that is given to the bank, my lord. My lord, and moreover, my lord, this is a case of civil nature, my lord. Well, I am not on the merit of this case right now, my lord.
Let us
As big,
report the state.
yes, my lord. That's because my husband who is going to be operated, my lord. Till then, till 12, my lord.
Quoted nj.com.
So-
Additional pay. Stop. Petitioners petitioner by invoking 480 section 482 BNSS is seeking pre-arrest bail in connection with Satigaon PS case number 156 of 25 under section 406 420 34. As per the FIR dated this at 2025 against the present petitioner and her husband. It is alleged that the informant made an agreement with them to purchase the vehicle for 17 lakhs. And the accused, the present petitioner, was supposed to clear the installments, but she, with the instigation of her husband, / co-accused, did not do so, due to which the informant had to pay rupees 13.5 lakhs. It is alleged that the accused persons have cheated him. In another connected case, no, it is not like another connected case. The learned counsel, Mr. Doctor, has drawn my attention to communication dated 4/4/2023. 2023 itself,
Yes, man.
but this is
22/5/23, my lord, page 90.
this is not pertaining to this, I think, this transaction.
May I,
Because this is letter is dated 4/4/23.
4/4/23?
But he says that agreement was made on 26/9/2023.
Yes, my lord.
Might be some other card.
Maybe,
because
my
the
lord.
allegation-
I
Better
am
not
not sure,
to,
my lord.
better not to mention.
Yes, man.
Look at it now. The husband of the present petitioner, accused petitioner, has been granted interim bail in another connected matter. Due to his health condition and to undergo the the advised surgery. Call for the case diary on the concerned police station. In the interim, in the event of arrest of the petitioner in connection of this case, allowed to go 25,000 with one surety, the like amount to satisfaction of arresting authority and subject to the condition that she shall she shall cooperate with the investigation and appear before the IO, making herself available for examination. Shall not hamper or tamper with evidence. Is the matter. 12-11.
I'm obliged, no? Deeply obliged.
May please lordship. No, the FIR is page 9 and 10, my lord. May I read, my lord?
9 and 10.
9 is the translated copy, my lord. 10 is the Bharna.
Okay.
With due respect, it is to inform you that my daughter Pooja Mondal, age 19 years, is a student of class 10 in Sunrise Academic, Kirtanpara. Last on 14/9/2025 at about 10 a.m., the accused number 3 with conspiracy took her to Tilpukhuri, the house of her friends, Rumi, by Pilpili, by calling over phone. But as per the plan of the accused number 3, the accused number 1 and 2 picked up her on bike forcefully by catching her hand and took her to Dangaigao very fastly by kidnapping, by threatening with dire.
আমার সাপ্লিট কি আছে বেল খিনি হি কৰি লম পাছত এডমিশন লম পাছত অৰ্ডাৰ্ছ
May please your lordship, just for time being, my senior is coming, my lord. Yes.
এইটো এ বি যে হুম Oh, yeah. CD was with me. It will be, কৈ দিলে দি দিব Adidas, CD to দি দিব. So that order which is fixed for delivery, na, that's ready. So you can have the CD. You can have the CD. There are connected matters in this. I'll take it up together. Just identify the number and after some time. খিনি একেলগে লৈ ল'ব।
15 is my lord, commercial quantity, my lord, MDT is my lord. I need some time, my lord, go to the PCR. Okay.
May I please tell us? In this case, my lord, for the same cause of action, my lord, the fresh complaint was lost, my lord. Because earlier, my lord, there was an FIR which was charge sheeted. And thereafter, my lord, after about 2 years, again a complaint was filed. And on the basis of that, my lord, fresh investigation was ordered. And the one investigation, again charge sheet is filed for the same cause of action. my lord.
Giving rise to two POXO cases. There
Two-
will be two POXO cases.
No, my lord. Two POXO cases, my lord. Already
POXO
same
cases.
cause of action.
Special sessions case number 260 of 23.
Yes, my lord.
This is the case, right?
Yes, my lord. What happened, my lord? In the fresh case, my lord, police filed final report exonerating all.
In the second case.
Second
This
case.
is the earlier case,
No, this is the second case. In earlier case, my lord, which was charge sheeted.
charge sheet.
Yes. Thereafter, my lord, again a fresh case was filed after about 1.5 years. Police, upon investigation, found that for the same cause of action, earlier the matter was charge sheeted. So investigation was completed. So police filed final report. Now, my lord, on
I have
being,
not understood.
yes, my lord, I'm,
What I'm trying to say, I'm
Yeah.
trying to understand is that,
Yes.
there were earlier, what the same cause of action, one case was filed.
earlier
That
case
was
was filed.
charge sheeted.
That was charge sheeted.
And then another case was filed over the same cause of action.
Same cause of
After
action.
1.5 years.
After 1.5 years. So it was, final report was filed in this.
Final report was filed. Thereafter,
The final report was filed showing that police saying that earlier case was investigated and would have charged.
file is final
Yes.
report, amalgamate.
Thereafter, my lord,
The same
yes,
thing.
thereafter, my lord, a fresh investigation was paid before the London magistrate,
It was directed.
directed, and which was investigated.
And then again.
Then
charge-
again charge sheet was filed for the same cause of action, ma'am.
Hmm.
So, my lord, already,
But because we'll need both the FIRs.
yes, my lord,
Because
yes,
to determine whether it is the same cause of
yes, my
action or
lord,
not.
yes.
Right.
Both are before your lordship, my lord. Because by way of an additional affidavit, I filed earlier documents, my lord, charge sheet, one additional affidavit is there, my lord. Earlier FIR, charge sheet, everything I have filed before your lordship.
Those scanned TCR has been received.
Yes, my lord.
However, uh, service is complete in the meantime. No, service is not complete. But as per office note dated 14/10/2025, service report of with regard to the informant is still awaited. The prosecution shall take instructions regarding such service upon the informant. Whereafter the matter can proceed. You just take the instruction, then yes, on the next date we'll hear it properly.
My lord,
We can-
since August matter is pending, my lord.
Both the affairs are here, no?
For the FIR, sir.
Then we'll study at that time.
Yes.
Fix. After we fix it. List the matter on. 23.
23rd of October. God bless.
But here the case has been registered under commercial quantity. In fact, lordship, it would be a case of intermediate quantity. Because the individual quantity recovered from the petitioner is lesser than commercial quantity. 3 persons were apprehended from trade. And individual quantity were clubbed together. And it has been made as commercial quantity. My lord, from the petitioner, 12.249 kg of ganja was recovered.
Since the case was registered against all of them,
Yes.
they
three
were
per-
together, one
Two-
case was
yes,
registered
yes.
against all of them.
Yes,
And the aggregate quantity is more than that. So therefore
Yes.
they have given this section.
my lord, under.
What will
scheme-
happen in this case then? Huh? It will be necessary, no doubt. But
But
in that case, what happens? Suppose 10 is received, 30. And 20 is intermediate quantity, suppose. Individually 10 is received, aggregate 30 is received, more than 20. Then will it be commercial?
Thing has to be find out whether my
Ah.
lord together my lord come or not.
Yes,
That is in
that's the
in
thing.
both
Otherwise,
investigation, that will
Otherwise,
come first.
being,
Otherwise, my lord, then my
being
lord-
criminal law,
Yes.
this beneficial interpretation has to
Yes.
be given anyway. The case diary is not yet received. Stop. The learned counsel submits that though penal provision pertaining to commercial quantity under NDPS Act has been given, but the alleged recovery from the alleged recovery of the contraband from the present accused falls in the bracket of intermediate quantity. Just for future reference, I'm writing. this.
Right.
Issue reminder for the case diary of Bongaigaon GRPS case number 68 of 2025. List on
Short date another.
My lord, 28, my lord,
28.
28, my lord.
Obliged.
May I please, Your Lord. My lord, hearing this case, my lord, petitioner in behind the bar for last 126 days, my lord. My lord, scan copy was called for, my lord.
Scan copy as for the law. 1410 office note, scan copy not yet received. And what about the service?
Service, my lord,
You have appeared, no?
appeared, my lord.
Yes. You are Mr. Tapata? No issue. sir.
My lord, since my lord, he is in jail for last 126 days. Next week may be fixed, my lord.
Scanned TCR not yet received. However, respondent number 2 is represented by learned counsel who seeks some time to file a written objection. That's true.
My lord, short date may be given, my lord.
Leaves the matter on.
Any convenience.
No, I wouldn't.
Because that it has to come, the PCR. It's from Borpeta, my lord, conversely. Borpeta.
27? 27.
Obliged, my lord.
It's a regular bail, my lord. It's a charge sheeted case, my lord. Here, charge sheet was laid, my lord, on 29/2/24, citing, my lord, 7 number of witnesses, my lord. Now your lordship will kindly turn to, my lord, page 37, my lord.
Additional affidavit has been
No,
filed.
my lord, that's same,
37.
37. It's a order dated 8/7/25.
Notice.
8/7/25. Charges were framed, my lord, on that day, my lord.
Okay.
My lord, now that court is also not, is not available, my lord.
No,
So-
page 38 is the notice.
Yes, my lord, that is
Notice
my ground, my
50
lord.
notice.
Grounds of arrest not given, my lord. And 39, my lord, 50A, next page, my lord, there is also no ground.
39 is also.
Yes, 50A, my lord.
You just, CD, LCR isn't received.
I have flag mark, my lord. I have flag mark that, my lord, notice, my lord. Flag mark position.
I'll give it back to you.
I have flag mark that notice, my lord.
Fifty-eight notice you did not find here.
Now, yeah, 50A notice I did not find, my lord.
Must be
50A,
there, we must have missed.
it must be there, my
Because you
lord.
have annexed a copy.
I have annexed it, page 39, my lord.
You can have a look, otherwise, if it is not there, he will be entitled to bail. It's right for, you want to see it? You can see it now.
My lord, if my lord has already gone through.
No, you can have a
My
look.
submission is that,
You
my lord,
ha-
that part, my lord, yes,
Ah.
my lord.
Yesterday. submission.
Yesterday also I made that submission, my lord.
Oh, sir.
Whether in the production order, that part is.
You
there
know,
or not.
he was shown arrested in this case, no?
No, no, my lord, no.
Arrested fresh. কালি আমি এটা অর্ডার লিখিছিলো নহয় সেইখিনিতে হৈ যাব খালি এইটো জাষ্ট ওপৰৰ পাৰ্টটো আই গিভ ইউ এইটো হ'ল 483 BNSS application seeking regular bail in connection with NDPS case number 138 of 24 under section so and so within bracket raising out of Bokhisto PS case number 613 of 23 and pending. It is at the stage of trial.
Yes, it is a stage of trial,
Pending before the learned special judge NDPS Guwahati.
number 5.
Full stop. বাকী কি হ'ব এইটো নটিচ দুখন উঠাই দিব লাগিব এটা উঠাই দিলে হ'ল মম্মীৰ পৰা এইটো লৈ ল'লে মই দেখাই দিম চিমিলাৰ কণ্ডিশ্যনছ উই কেন ডিছপ'জ অফ দেই Could you find a 50A notice? 50A notice is not there, I think.
Madam, 50-year, madam, already, madam, notices, madam, here, madam, annexed in the petition.
No, 58 the next, but in the record they have missed.
50 is not there, and even in the production order, madam, those parts are not there, madam.
Well, whatever is there, they'll follow.
Madam,
From now onwards, IOS should follow it properly.
madam.
They also did not know
Now,
at that.
most
At
of
that,
the
in
cases,
earlier
madam,
times, it was
they
like
are
this only.
following, madam.
This was the format in earlier.
Earlier, madam.
It's okay.
23 group, madam.
No problem. How about it all? This will be disposed of.
Madam, I am obliged, madam.
Same terms and conditions I'll dispose it of. So I'm not dictating, repeat. It will I not, that I will let my decadent. Dispose it. Yes, Mr. Boyd, 20, no, this one?
Item 20.
Hmm.
Lordship, I have communicated and I have received instructions, my lord. My lord, this is special case number 52/2025 arising out of Patharkandi PS case number 133 of 2025.
Charge sheet, no?
Lordship charge sheeted. The charge sheet is bearing number 145 of
Record is sufficient.
2025,
Uh-huh.
dated 24/9/25, my lord.
Full stop. Report, লিখি থাকিব। আর DK বৈদ্য, তাৰপিছত K বৈশ্য, learned additional fee. It is submitted that in the meantime, the case has been charge sheeted by CS number
145 of 2025, my lord.
145 of 2025 under
Date-
section so and so kiba. This, do you have the sections?
Yes, my lord. My lord, 21C, 25 and 29 of the NDPS Act.
In the context of the same, in the context of the same, the learned counsel submits that the accused may be permitted to approach the learned trial court for regular bail.
My lord,
Where is allowed,
disposed of on those grounds, my lord.
then disposed of on the said terms.
Deeply obliged, my lord.
May it please your lordship. This is a regular bail application. Accused is behind the bar for last 40 days for the alleged offence under 40.
Add to my lord.
Have to, madam.
22, 23, 24.
May it please your lordship. Well, time for item 22.
Well, I am for item 23.
You are for 23
My.
and 24.
My lord, in item 22, my lord, the present petitioner is a lady man and she was arrested on 25/7/2025. Today is 84 days she is behind the bar. The allegation pays is, my lord, 11.
Hmm.
The affair lost, my lord, the president of APSU.
Let us see the FIR.
Yes, my lord.
At
Page 11, my lord.
common case, we see the FIR first.
Yes, my lord.
23/7, right?
Yes, my lord. 23/7 affair was lost with most respectfully begs to state that on 7/7/2025 at about 10:30 AM, one minor girl, namely so-and-so of village so-and-so, P.S. Dhupdara district Golpara. I've seen the order sheet, my lord, that with TCR also called for. So
At the
here
time,
is,
taking steps, sometimes they correct. What has come?
Sarshit for me.
Child marriage matter.
My lord, a short date may be given. Here, what happened, my lord?
Matter.
Issue number
Yes, let me see the.
2 is the father of that alleged victim.
It's not, along with case diary. Case diary has also been called. What about the notice? There is no mention in the
We have
office
taken the steps also, my lord,
steps.
already. So a short date may be given, my lord.
In this case, by mistake, TCR was called, scan TCR was called, though case is stated to be at the stage of investigation. BA 3176, huh? 3176, item to 24, 25, item 25.
25, my lord.
Further, though notice upon respond number 2 informant has been taken, but service report is awaited, the prosecution shall take instructions regarding the said service. Further, call for the case diary of
Tamarhat PS, my lord, 84.
Tamarhat PS case number 84 of 2025 under section so and so of the act. The accused person, that both the accused persons seeking bail herein are stated to have been arrested on 13/8/2025. This is the matter on, you suggested date, 25/10. 29/10, or 25 is holiday, 29/10, okay.
29. Obliged, my lord. May I please the lordship? With regular bail application, my lord. NDPS 21B, my lord. 36.41 gram heroin has been recovered from the car of the petitioner, my lord. And in this connection, my lord, another accused was granted bail on 14, my lord.
After the conflict case, they have stated that they have to absent the complainant from that petitioner also. That's why because of the poetry statement, that's why lordship has granted the bail.
Diary has come.
That is only the recovery was made from the this petitioner also, and about other person.
This 50 days.
We have not received the offensive report till now. 36.41 grams heroin suspected to be.
Allegations to Diablo, Para 3. Similar. Co-accused. The case diary has been received. And it is FSL report is awaited. And FSL, which reveals that FSL report is awaited. And the other investigation is almost, has, other investigation appears to be completed. And stuff. The learned counsel submits that one co-accused, namely Habibur Rahman, was granted bail by this court on 14/10/2025. It was the said order. The investigation is stated to have revealed incriminating materials from the present accused. And it is also revealed therefrom that prima facie contraband in the form of narcotic drugs was recovered from these persons. Nevertheless, considering the progress of investigation and also one aspect of parity, I am of the considered opinion that this accused can be granted bail at this stage, subject to suitable conditions. Can you tell you? Para 6. Bail petition stands allowed and disposed of on the course of terms. Return back the case there. Right? I can keep it. 6.
After sometimes, my lord.
That's not the sentence. Utasana.
In this case, although CD was called for lordship, Palace page 17 lordship, they forwarding report lordship. After 2 days, my lord, judicial, police custody lordship, he was produced and my lord, page 17 lordship. Second paragraph lordship. The investigation was completed. This is the, my lord, statement of the IO lordship. A doctor, my lord, medical officer, medical and health officer was arrested lordship. Today is 35 days lordship. My lord, if the IO stated, my lord, the interrogation is completed lordship, my lord, my submission is that no.
Can I see the FIR?
FIR is at page lordship.
Diary has been received,
12, Lordship.
not received. Let me see the FIR.
Page 12, Lordship.
It's 12.
My lord, the superintendent of hospital, my lord, had
Yes,
conflict
yes,
with the petitioner lordship. And ultimately, my lord, my lord, judge, my lord, made a conspiracy lordship against the petitioner. He was also, my lord, the medical and health officer, nodal officer of that.
He is also arrested.
My lord, that lady was arrested lordship. My lord, thereafter, my lord, the
Big
petitioner,
certificates, big certificates.
petitioner was arrested lordship. My lord, if my lord, IO says, my lord, interrogation is complete, my lord, my lord, the further detention may not be, my lord, serve any purpose lordship.
When can you get the case diary? From which state police? Gwalpara?
36 days lordship.
The Mr. Ahmed Learned Council
A short date may be given
comes,
lordship immediately, my lord, after.
submits that the present accused was arrested on 11/9/25,
My lordship.
has completed 35 days. And draws attention to the forwarding report wherein the draws attention to an application by IO dated 13/9/25, stating that the interrogation this is producing the two accused persons arrested from police custody. Good stuff. However, the case diary of Gwalpara PS case number 175 of 2025 pertaining to this case was called for but not received. Good stuff. Issue reminder for the same.
May it be on my lord, 22 lordship, 22nd lordship.
If it comes to 22, no, 22 is a holiday, I think. So is it a holiday?
23rd may be lordship.
No, 22 is not holiday, it's open. 23rd,
Lordship,
23 10.
oblige lordship.
Lordship, only 2 kg 48 gram ganja recovered from me. And the special judge Shivsagar rejected my bail application, taking note of the applicability of section 37 of the NDPS Act. So Lordship, it is an intermediate quantity, section 37 is not applicable.
Now, intermediate, where is the order?
Order is, Lordship, I am referring.
2.4 cases are suspected.
Lordship, order is on Annexure C, page 19. Annexure A is the charge sheet, or there is also seizure list.
No, I see, I think slight error was made. 37 is not applicable everywhere. Charge sheet.
Yes, charge sheeted case, already 85 days I am in the custody and taking note that section 37 is applicable, my bail application rejected.
Oh, no problem. It is available.
No, only the law point may be decided, Lordship, whether in intermediate quantity 37 is applicable.
It is applicable to commercial quantity.
yes.
And section 27A,
Yes.
which is financing drug trafficking, and one more section. What is that section? 19 or 8 or something. There's one more section where it is applicable. Let us clear now only. Section 19, 19, 24, 27A, and commercial quantity.
Yes.
These are. Heard, and so, and Goswami. The petitioner, the accused, Raj Ahmed, invoking section 483 BNSS, seeks a regular bail in connection with special NDPS case number 17 of 25, pending before the learned special judge Shivsagar. The case arose out of Simoluguri PS case number. Simoluguri PS case number 13/2025 under section so and so. Of the accused is stated to have been arrested on 24/7/2025. The allegation is about recovery of uh, 2.48 kgs, 48 kgs of suspected ganja from the house of the accused. Full stop. Ganja is 1 kg and 20 kg. 120 kg. The said quantity of ganja would fall in the bracket of intermediate quantity. And therefore, the rigors of section 37 of the NDPS Act may not be applicable. The case is stated to be at the stage of trial. Prosecution evidence is going on. But PCR not received.
Lordship may consider the length of detention and the seized quantity of the ganja.
How long, how long he is in custody since?
85 days total, Lordship. The investigation is complete. Further detention may not be required, Lordship.
So should we get this TCR or dispose of on this basis?
The stage of the trial, Lordship, that
Lordship, the trial, charge sheet is here, copy is here. Here is the copy of the charge sheet available annexed to the bail petition. Full stop. Considering the fact that the case upon completion of investigation is poised for commencement of trial, and also the length of detention, that the accused herein is hereby allowed to go on bail of ₹30,000 with one surety of the like amount to the satisfaction of the concerned learned court. Special Judge Sivsagar. And subject to the conditions that number one, he shall be available for the trial. Number two, he shall not hamper or tamper with evidence. He shall not indulge in any illegal activities or offenses. Right? Violation of the bail conditions would lead to cancellation of the bail. Full stop. The bail petition stands allowed and disposed of.
Lordship.
Proceed on.
Obliged.
May I please, your lordship? Here, my lord, with all respect, my lord, may I come to the FIR, my lord? That is that page, my lord, with all respect, my lord. Page 18, my lord. But prior to reading the FIR, my lord, this accused, my lord, with all respect, my lord, he was initially arrested in connection with a case wherein he was allowed to go on bail. And right after being released on bail, my lord, at the doorstep, he was arrested in connection with the present case. The FIR is before your lordships. And in this FIR, there is no mention of him. Even the sections of law attributed would possibly cannot be attributed to the case, my lord. If I read, leaving aside 5 lines, lordship is reading, my lord, I should not read, I think.
Page 18, I'm on that.
May I, my lord? My lord, leaving aside 5 lines from the top, my lord, why I am reading, my lord, because the sections of law attributed, my lord, with all respect, my lord, attempt to murder and all those, my lord, they cannot be attributed, my lord. 18. On this, the mob became agitated. But this is the day, my lord, wherein the dead body of the singer was brought to Guwahati, my lord. And the accused happens to be the president of the Jubin Garg fan club, my lord, X. On this, mob became agitated and started using abusive language towards the police personnel on duty. They pushed the police personnel and tried to overpower the police. At the time, CDSP Jalukbari madam arrived on the spot in her official Scorpio so-and-so. The unruly mob attacked her official Scorpio vehicle bearing number so-and-so. The unruly mob attacked the Scorpio vehicle of CDPS so-and-so while she was inside the vehicle. As a result, the rear side glass of the vehicle was damaged completely, while the windshield of the glass got damaged partially. This amounted to attempt to murder, my lord. And to be precise, my lord, absolutely it is apparent by reading the forwarding report that at the place of occurrence, at the time of occurrence, this accused was not present, my lord. Why he was arrested in connection with this case, this is, I'm reading the forwarding report of the earlier case wherein he was granted the privilege of bail, and the my lord, re-arrest cannot be carried out in this manner. It begins at 23, wherein I got bail, my lord, earlier case. I turned the page, my lord, 23. Thereafter, again I turned the page, my lord. At page 25 it occurs, my lord. No. Like the Heriko. I'm sorry, my lord, I'm like the Heriko. Lordship, but kindly have a look at page 36, my lord. Forwarding report. In the present forwarding report, my lord, wherein I have been arrested, it shows, my lord, page 36 at the top, my lord, with all respect and folded hands, my lord. Lordship may have found it, my lord. Page 36, my lord. During investigation, see Mintu Boyso of Fotakilambari PS informed that while investigating Fotakilambari PS case number so-and-so, it was revealed as Victor Das, he is not before your lordships, my lord. He has been booked under NSA, my lord. And Ajoy Fukon, he is before your lordships, my lord. So-and-so were actively involved in the mob violence and vandalism at LGBI airport. This affair was lost, my lord, on 22/1, whereas I was arrested in the subsequent case on 26/1. On day 1, I was enlarged on bail and without execution of bail bonds, my lord. Thereafter, what it says, my lord, subsequent investigation revealed both the arrested accused persons criminally conspired. This is regarding conspiracy, not present at the spot, no allegation. They destroyed public property, not me, my lord. The rest who were present, both the arrested accused persons incited the mob to create lawlessness. My lord, the statements of Onkur Medi and so witnesses corroborate their criminal conspiracy. Have I made my position clear, my lord? As regards criminal conspiracy. And my lord, Onkur Medi, who was the kingpin of this case, he was enlarged on bail, my lord, on day 1. And his forwarding report, my lord, we have also annexed. That does not also mention my name. That occurs at page 49. And this page 36 is disastrous, my lord. Parting paragraph. However, it has come to notice that both...
Page 36?
Page 36, my lord. Again, I am rereading, my lord, why I have been arrested in connection with this case.
Page 36, para?
Last parting paragraph, my lord. Prior to criminal background of Victor Das, not me, my lord. However, it has come to notice that both Victor Das and Ajoy Fukon have already been granted bail today. Lordship has seen, my lord. On 26/9, in Fotakilambari PS case number so-and-so. Therefore, for the purpose of further investigation, it cannot be, my lord, in a different case. Further investigation has to be in the same case. And custodial interrogation, both of them have to be arrested in Ajara PS case number so-and-so. 26, I was enlarged on bail. 26 at the doorstep, because the Lanet court below never asked us to execute bail bonds, my lord. We were allowed to, we were let off, my lord. So exactly upon being let off, we were re-arrested. And the law is clear, my lord, from Udoy Chand. May I just, my lord?
Yeah.
Udoy Chand, my lord, with all respect, my lord. Here, my lord, with all respect, my lord. It begins from Udoy Chand, Pandora's box was open, my lord. Para 5, my lord. Lordship may have. Paragraph 5 of Udoy Chand, my lord. Leaving aside 1, 2, 3, 4 lines from the top. We are quite amazed at this statement. We should be expected that if after the order of bail passed by us, in this case passed by the Lana Judicial Magistrate, my lord, here it was Apex Court, my lord, the authorities of the state considered it fit to arrest any of the petitioners for any other offences. It was their bounden duty to apprise this court before taking these persons in custody. Have I made my position clear, my lord? Especially when no disclosure was made to us when we passed the order of bail that any case or cases were under investigation against any of the petitioners. Because, my lord, on 26, when I was allowed to go on bail, the 22 case, the FIR of this case where I am seeking bail now, my lord, rearrested, that dates back to 22, my lord.
So it was there.
Despite that, I was arrested, and there are several other authorities, my lord, at our High Court, my lord, and another one is very important, my lord. Kamal Datta, my lord.
It's our High Court.
Our High Court, my lord. Basing on that apex court, my lord, Kamal Datta would be, my lord, para 23, my lord. Can I just?
Yeah.
Here also set at liberty, my lord, at para 25. Tailor-made, my lord, 24, 23, 24, 25, my lord.
Reference to Uday Chand is also.
It has begun from Uday Chand, my lord. Uday Chand has been quoted, and this is our High Court, my lord. Para 23 last lines are important, my lord. Arresting the accused in a different case from outside the court. Exactly like this, my lord. Outside the court, I was arrested, where he was granted bail without disclosing to the court about the need to arrest him in another case is wholly unacceptable.
The investigating authority thinks that bail should not have been granted after it was granted, then it can always challenge it.
Absolutely,
By way
my
of seek cancellation or 482, they can challenge.
Lordship is
That as the bail order being arbitrary or whatever, because no revision lies against bail that we know.
Well-
Anyway, so this is the thing, right? So should I go to the prosecutor? He's in custody since when?
27-9, my lord. 26-9 re-arrested, produced on 27-9, my lord. 19 days.
Go ahead, sorry.
Waiting for receiving the dead body of the hardwork, that's our singer, the Vivon singer, peacefully. These two persons, one is Krishna here, another person Victor Das, is instigating the people that for seeking justice for his, the singer dead body. Then we will not get justice if we not use this violence.
No, how can it be?
That
I was not present, my lord.
But only thing is here, okay, one person accused, one another Ankur Mehdi is stated categorically that yes, he is a person who instigates the public to create a situation like Nepal. And in cases are there also, I have checked my also.
My lord, kindly ask him whether we are present or not, my lord. No name in the FIR, nothing, my lord. We are not present, my lord. Cannot be.
Is there any material to indicate their presence at the place of offense? That is what.
Statement, he was present on there.
I told. Mehdi, Mr. Mehdi.
Yes, Ankur Mehdi.
Ankur
He's
Mehdi.
sitting there, yes.
But Ankur Mehdi forwarding report we have annexed, that is at page 49, subsequent creation, it is nowhere my name is mentioned, my lord. And that is why they write in my forwarding report this time, my lord, that conspired. Being present is not, page 49, my lord. If he's ready in totality, my lord, with all respect, my lord.
Date?
49, our bail application, my lord.
Yes, I've seen. I've got it now. Forwarding of Ankur Mehdi.
Grounds of arrest and reasons of arrest, nowhere I am there, my lord.
Apart from the statement of Ankur Mehdi, there's
An entire allegation was against that other person.
other person. Okay, go. Go. Okay, we can have a seat.
But you can calculate, I think,
Huh? I can, I'll just. I think it can be given. third learned senior counsel, B.K. Mahajan, assisted by N. Mahajan. And D.P. Goswami learned additional PP for the state, the instant bail application. You can have a seat.
My lord.
5 minutes will take. The instant bail application filed under 483 BNSS, seeking bail for accused Ajoy Fukon, stated to have been arrested on 27/9/25 in connection with Azara PS case number 142 of 2025 under so and so section. The case, the said case arose out of FIR dated 22/9/2025, lodged by SI of police, who at the time was IC of Borjar outpost. It is alleged that on that day, he and others were doing duty at the airport in connection with the arrival of the dead body of late Jubin Garg. And in that situation, a mob collected and started abusing the police. Subsequently, subsequently the mob became very unruly and attacked policemen and damaged vehicles and cameras of journalists. And it is alleged that the mob created a chaotic situation at the place and prevented police from doing this duty. No persons by name are mentioned in the FIR. The present accused was arrested during investigation of this case. Learned Senior Counsel has drawn attention of this court that immediately after being granted bail in another case, the present accused came to be arrested in a malified manner. In support of the same, the Learned Senior Counsel has placed before the court decision of the Honorable Supreme Court in the case of Uday Chand versus Sheikh Muhammad Abdullah, 1983, 2 SCC 417, where it is submitted that drawing attention to para 5 of the said decision, it is submitted that the Honorable Apex Court has deprecated the practice of arresting a person immediately after being granted bail without bringing the fact before that said court that other cases are pending. A reference is also made to the decision of Kamal Datta and Union of India of this court reported in 2015 3 GLR 346. In the said decision, also reference is made by this court to Uday Chand within bracket Supra, drawing attention to the Learned Senior Counsel draws attention to para 23, in which this court has observed that arresting the accused in a different case from outside the court, where he was granted bail without disclosing to the court about the need to arrest him in another case is wholly unacceptable. The Learned Additional PP submits that though the accused is not named in the FIR, but from the statement of co-accused Ankur Medhi, it is revealed that he was present there. However, the learned prosecution fairly submits that other materials are not there regarding his presence at the place of occurrence. What is the progress of investigation? There appears to be reasonable progress in the investigation as well, despite the elapse of about 20 days from registration of the FIR. In the given facts and circumstances, I deem it fit to grant bail to the accused. Accordingly, so and so is allowed to go on bail of rupees 30,000,
My lord.
on surety of the like amount, to the satisfaction of the concerned learned court. This would be CJM Kamrup. Huh? Yeah, conditions can always be imposed. CJM Kamrup Metro, and subject to the conditions that number 1, he shall cooperate with remaining investigation. Number 2, he shall not hamper or tamper with evidence. number 3, he shall keep peace and not misuse his liberty to commit any illegal or unruly activities or offences.
My lord, my lord. My lord, 25 days from the date of registration of affair, not 20 days. My lord.
More than 20 days. More than 20.
And my lord, that senior advocate, I am not a designated senior, my lord, that may be omitted, my lord. Ah, that may be-
It's okay, no
that-
problem.
that-
Done.
Highly obliged, my lord. Obliged, my lord.
Length of practice.
My lord,
In our eyes, you are a senior.
My-
Your son, no?
my son, my lord. Highly obliged, my lord.
Good to see him. I think
Thank you.
he had joined. When did you join?
16 months.
Oh,
My
after
lord.
I left after December 2011.
My lord.
Last
my lord.
time I was in Goa.
My lord.
High Court practice. The violation will entail cancellation of the bail. The return back the case diary, the bail petition stands allowed and disposed of.
My lord.
Can I keep this too?
My lord, my lord.
Notes from it. Okay. Hold on, huh? 27.
May it please your lordship, here the case diary was called for, my lord. My lord, page 13 is the FIR, my lord. FIR relates to an allegation that, my lord, the informant, my lord, the present accused, my lord, by mobile number, my lord, he called up, my lord, the informant side and stated that, my lord, page 13, my lord. So there is a case against them. There is a complaint in the CM Vigilance, my lord, against the informant side. And the informant of that case, my lord, had demanded some amount, that is around, my lord, 2 lakhs for removing the complaint. And also he demanded for himself a 25,000, my lord. Subsequently, my lord, this last para lord should find, my lord, the informant side went there, my lord. Thereafter, my lord, this accused, my lord, he came, my lord, and he was apprehended. Now, my lord, here case has been registered under, my lord, 305E and 3084, my lord. Both, my lord, maximum period of, my lord, punishment on conviction is 7 years, my lord. So here, my lord, why, my lord, that notice was not served, my lord? On, my lord, merit, my lord, that length of detention around 40 days in custody, my lord, 41, my lord, 41 days. 41 days in custody. Now, my lord, kindly have a look at page 20, my lord. Why, my lord, that 35(3), my lord, earlier 41A was not resorted to, my lord? That lord should find, my lord. Page 20, my lord, I'm sorry, page 20, last, my lord.
Okay.
So here, lots you got it, my lord.
Grounds of arrest.
Yes, my lord. Last, my lord, serial 8, my lord. Then
Furthermore,
Furthermore, yes, my lord. Furthermore, the arrested accused person might abscond or destroy the evidence if they are released on bail after issuing notice under 35(3). So first contention is that they might abscond or they might, my lord, destroy evidence if they are released on bail. And there are another aspect that they might commit similar crime and destroy evidence if released on bail. Now, lordship, we have filed one additional. Oh, I'm sorry, my lord. Lordship, kindly see the order, my lord, passed by the learned magistrate, my lord, while he was produced before the learned court, my lord.
page 26.
It starts from page 21, my lord.
21.
It starts from page
Okay.
21.
Uh-huh.
And if I, subject to what my learned colleague states, my lord, APP, my lord, there is not a single line, my lord, why, my lord, 35(3) was not resorted to, and the satisfaction of the learned court, my lord. That 35(3) is not necessary, my lord. Because that 35(3), my lord, earlier 41A, my lord, as per the judgment of Honorable Apex Court, my lord, that entails case, my lord, there it has been stated, my lord, the learned court below has to consider it, my lord. Why 35(3) not resorted to? And if the same is not considered, my lord, the
35(3) is that you have to be, if you are given a notice,
Yes.
and you appear, then you cannot be arrested unless there sufficient grounds are there, because you have complied with the notice.
Yes.
That is not 41. It was earlier
A.
41A. Now it is 35(3).
yes, my lord. Now
Come to that.
that satisfaction is not there. And my lord, that one line, if you also that until judgment, my lord, if you
Yeah.
also kindly have a look once, my lord, we are placing it, my lord. That para, my
Now
lord.
all these have to be read, Anesh Kumar, Antil.
Exactly, my lord.
Then your Purkashta.
Yes, my lord, develop-
All have to be read together. no?
Developing, my lord, yes, my lord.
Okay.
Kindly see, my lord, para, my lord, 100.3, my lord, that is the summary conclusion, my lord. Last but one page, my lord.
Yes.
So it's like, my lord, that the courts will have to satisfy themselves on compliance of 41 and 41A. Both, my lord. Well, now, my lord, 35, 1, 2, and 35, 3, my lord. So both has to be, my lord, the court has to be satisfied as regards the compliance, my lord. And any non-compliance would entitle the accused for grant of bail, my lord. So here, my lord, neither discuss, the investigating agency stated only that they might, my lord, he might abscond, he might destroy evidence, and he might commit another offense, my lord. And in the checklist, if your lordship go through, we have placed, my lord, by way of an additional affidavit, my lord,
At page.
at page 90, my lord, of the additional affidavit, my lord.
Yeah.
My lord, there, lordship, kindly have a look at that serial 1A, my lord, capital A, my lord. To prevent the person from committing any further offense, nothing is there, there's blank, my lord. And now kindly have a look, my lord, the number 2, my lord, down below, my lord. The facts, reason, and conclusion of the police officer for arresting the person. My lord, there they have stated to prevent the offender from committing any other offense in future. But, my lord, kindly see furnished details, my lord. So details has to be there. The lordship knows, my lord, much than us, my lord. So, my lord, here, my lord, those reasons
I'm
never
also
given.
learning.
No, my lord.
So this is the thing. So these are contention.
My lord, my lord.
He's in custody since
My lord, he's since, my lord,
6/9.
6/9, my lord, 41 days, my lord, and there are few orders passed by this honorable court, my lord. Should I place it, my lord? On that line, my lord.
On 41A.
Yes, my lord, not necessarily.
Always useful.
Yes, yes, my lord.
If you have brought.
Well, we have annexed, my lord, page 42, that relevant part, my lord. Page 42, my lord.
Yes, yes.
Now that para 21, last page 42. Para 21, last line. When arriving at such satisfaction, the arresting police officer is also required to record his reasons in writing. Thereafter, my lord, para 22 also, my lord, I'm just reading from in between. After the arrest, that fourth line, my lord, it appears that the forwarding report contains detail in the accusation made against the petitioner. However, at page 4 of the said forwarding report in paragraph so, investigating officer has mentioned that unless the petitioners are arrested, there may be a possibility of hampering and tampering with investigation, like us, my lord, in this case. And there is also a chance of their fleeing from the course of justice. It is also mentioned that they are to prevent the petitioner from indulging in or threatening or making any promise to other witnesses to dissuade them from disclosing truthfully before the investigating officer, the arrest was necessitated. Thereafter, my lord, para 23, the observation of this honorable court, my lord. The apex court has, in the above referred cases, deprecated the practice of the arresting authority of mechanically reproducing the condition mentioned in the statute regarding satisfaction of the arresting authority for necessitating the arrest. By merely stating that the arrest of the petitioner are necessary for preventing them to so, my lord, like the, now, unless, my lord, then I'm skipping those, unless the investigating officer mentioned the facts which led
That's
him to
true.
believe. Exactly, my lord.
The furnished details column which is there, no, that there, it means that furnished details of any other cases.
Yes,
will
my
be
lord.
there.
And why he
And
came into
other-
that
why-
conclusion.
I know, because there may be some, anyway, these are the things.
On that count, my lord, possibly that violation is there, and length of detention around 41 days, my lord, and these are 60 days.
But
mandatory.
allegations pertain to corruption, kind of.
They demanded money, yes. my lord.
Corruption, kind of corruption. That's
Yes,
why
but no delivery, my lord.
yeah,
Lucky-
vigilance cell has come.
Yes, no delivery of money was there, my lord. Taking into account, my already suspended, my lord, and violation of that, my lord.
He's
Possible.
suspended.
Already suspended, yes, my lord.
Anyway, you submit and.
Along with the complaint of the other authority. accused of the other case, which was from, the letter was fraudulently taken by him.
Acha.
It was forwarded to the same residence.
Later, other case means which one?
Other case means that earlier one, that letter, which was reflected the case, which was sent to the
Acha, acha.
vigilance.
Okay.
That he was, he has said, called up, that accused that the compromise was been fully made on the non-demanding of 2 lakh rupees and he will 25 rupees on that. The 2 lakh 25 rupees demanded by him to compromise the case.
We
That is
should,
the allegation.
Police should follow this, this kind of cases, especially they should follow this notice requirements fully. So there's no grounds on technical infirmities. Anyway,
My lord.
investigation has progressed.
Yes, in progress.
I can have a look
The
also.
department was an employee of the.
All documents seized, my lord. I'm just page 69, my lord. We have annexed the seizure list.
As an employee of. Now he, working as a dark section, as a dark runner.
69 is the seizure list and 71 is that, my lord, he has been suspended, my lord, placed under suspended already. Page 71, my lord.
The case there is also only 6 cases there, but regarding the 35 feet of each, that is not in the, I have not found the case. Other than 44 and 48 cases are there.
Let me have a look.
Not
Tax criminal of Avoid heard Mr. A. Chaudhary, assisted by M. Mohajan. And D.P. Goswami, learned additional people. The accused petitioner, Ratul Deka. 6 regular bail under 483 BNSS in connection with Dispur PS case number 74 of 28 under so and so BNS. He was arrested in this case on 6/9/2025 and stated to have completed 41 days
My lord.
in custody at the moment. He was taken in remand. Police
Yes,
remand.
yes, my lord. 2 days, my lord.
It is
2 days,
submitted
my lord.
That he was also taken into police remand for 2 days and custodially examined. Good stuff. Apart from the issue of length of detention, the learned counsel, Mr. Chaudhary, has contended that there has been there has not been proper compliance with section 35(3) of BNSS within bracket corresponding to section 41A of CRPC. So my attention has been drawn to the grounds of arrest mentioned in his forwarding report. One of which is that he may involve himself in other cases.
Right.
Drawing attention to the checklist in this regard, it is submitted that the details regarding such satisfaction is not recorded. It is also submitted that in the remand order of the learned JMFC, the satisfaction regarding 35(3) has not been made as required by the law laid down by the Honorable Supreme Court in the case of Tatendra Antil versus a state versus CBI. Good stuff. The principles have been summarized in section para 100 of the said order. The petitioner counsel also relied upon a decision of this court, of a coordinate bench of this court in bail application number 2768 of 2025. We didn't write naam to likhe diyo. Arihan Jain and another versus State of Assam, in which these aspects were gone into. Para 23 of the said judgment, to which reference is made by the petitioner side, is reproduced herein below. At page 43. Good stuff. The learned additional Public Prosecutor, Mr. Gosam. Places the case diary for this court. Upon perusing the materials, I find some force in the contention of the petitioner counsel regarding non-compliance or defective compliance with the provisions of section 35(3). The present accused is stated to have been already suspended and the documents seized. In this regard, attention is drawn to Caesar list annexed as
Annex F, page 69, my lord.
16 and Caesar list annexed as Annexer F.
My lord.
Within bracket, page 69. ওইটো allegations লিখিব পাহৰিলো নহয় এইটো কথা এইটো আগত লিখিব লাগিব মই সোমাই দিম এইখিনি লিখি লওক আপুনি The allegation in the FIR dated 5/9/2025 is that he received a telephone call from an unknown number about a complaint regarding him in the CM vigilance cell and asked for rupees 2 lakhs to 2.5 lakhs to settle the same. Pursuant thereof, a complaint was lodged and then the present accused was apprehended. Undoubtedly, the nature of the allegations is serious, having bearing on public administration. Full stop. However, considering the above aspect regarding purported non-compliance of section 35(3) of the BNSS and also the semicolon, the suspension of the present accused in service and also the progress of investigation. Dash, perhaps the accused who has completed 41 days in detention can be released on bail, subject to suitable conditions. Accordingly, is allowed to go on 50,000 with one surety of the like amount to the satisfaction of the concerned learned court. CJM Metro.
My lord.
So, and subject to the conditions that number 1, he shall cooperate with remaining investigation. Number 2, shall not hamper or tamper with evidence. Shall not try to influence or threaten witnesses. And shall not misuse his liberty to commit any illegal activities or offenses. In case of violation, violation of any or more of the bail conditions, the IO would be at liberty to move an appropriate application through the prosecution for cancellation of the bail. Return back the case diary, bail petition stands disposed.
Much obliged. Highly obliged.
Kaplin, এইটো কিমান আছিল? মাজৰ ন?
May I please your lordship?
Subsequent, no?
483 application.
Ah.
Petitioner was arrested on 3/2/2024, lordship. Today is about 1 year, 8 months, 13 days, lordship.
Just commercial quantity.
Commercial quantity. In this case, final complaint submitted on 1/8/2024, charge frame on lordship to 2012/2024. They have cited 13 number of witnesses, and out of 13, only 2 examined, that 2 even lordship only chief part that they have completed, lordship. Na? So lordship, in this case, we have taken the plea on last occasion, we have mentioned, lordship, we have taken the plea for non-compliance of lordship, section 50A. 50 they have complied with, but section 58 they have not complied with petition. So Lordship, in this case, after their arrest, Lordship, no, they have issued the notice under section 50. Thereafter, the mandatory section 50A is not there, Lordship. So, my lord, that here in this case, 4 number of accused involved, Lordship. That even from the train, it was recovered. Both her husband and wife and 2 more others were also there. From Samsudin Kazi, nothing was recovered, Lordship. And though interception inside the train, but Lordship, the recovery is made at their office. Nothing researched at the police station, at the place of interception, Lordship. So in this case,
The commercial quantity is 4.1.
Yeah, let us go into this first technical aspect. Huh?
yes,
For 50 notice, I think I found it to be reasonably okay
Lordship.
because the grounds have been given. All that they had to do is just they give this in another sheet to the
Yes.
family.
Yes.
But 15 notice, I think probably not given, right?
Because
Yes.
they were arrested in the, actually detained in the railway
Arrest memo.
platform. After that, they have brought them their office because of the crowd and all the passengers in the railway station.
Okay,
After
okay.
that, all their bags and luggage is opened up. Around
Understood.
4.141 kg. Morphine was found in their ladies' bags. 2 ladies were all with all these 4 accused. And Samsudin Kazi, the petitioner in this case, is the prime kingpin of this all this network. Because the one named Alex named person is the main person who engaged these 4 persons to carry the contraband to the Farakka from Silchar. This is the case. When they were arrested, the arrest
Yes, missing.
were served and their acknowledged is there in the with independent witnesses signature is also there. But their address is so far and they were not communicated through the.
No, even I think even if, suppose in a situation like this, if they are when they are brought, obviously we have to be practical also. So an honorable apex court has never said things which are not practicable. So immediately after they are arrested and brought to these things, their relatives number, everything has to be taken. This notice can be sent like that also electronically. But it seems it was not done. So because if there is no compliance, they will be entitled to bail. That's a fact.
Their daughter is already informed their phone number. The arrestment was said.
50A notice is there.
No.
Notice is not there, I think.
Notice is not.
Not there. No, don't worry about that. If it is not there, it is not there. We can't help it. Because fact is fact. You just have to find the fact, whether it is there. If it is there, we have to see whether it complies. If it is not there, then we can help.
Regarding this issue, my lord, I want to place a coordinate defense order. Recent order. And the one more is a FX code order. Here the
Darshan,
Darshan.
Darshan, actually, the division bench has said that you have to
Yes.
follow the earlier
Yes.
terms of Pranay Sethi.
Yes.
So anyway, so far, so I am following on those lines only, but kindly give me the coordinate bench order.
My lord order is also there. Lordship.
Don't show me. Still learning.
But my lord, before going through that,
I'll
Lordship.
come back to you. I'll
Lordship.
come back to you. Just,
Lordship.
we have not completed. Let's come back to you.
And one visiting team also visited their home. And their daughter already informed that he has the knowledge of their parents' arrest.
No, actually, no, it's okay. This I also agree. The 50 notice is Nowadays, it is given in still better format. Things are getting better and better. It is getting nowadays given questions serial number wise in bilingually, not only in English but also in another language. But at that time, in 3/2/24, this was okay. This will pass the test. The 15 notice, in my opinion, will pass the test. But if 50A notice is not there, which has been held to be mandatory in Bihan Kumar, the second part of the opinion, the second, the learned judge, Justice Singh, Kotesa Singh, is given the second opinion. That will also be binding. So otherwise, on 37, probably there are a lot of materials. 37. On merit, there are a lot of materials, it seems. 37 tests, we don't know. We have not gone into it because if bail has to be granted for technical grounds, then it becomes an academic exercise.
Yes.
37, right?
My lord, regarding.
Only when there is no such ground taken, then only you. Anyway.
Because the persons that they were involved, they were.
My lord, there is a mandatory provision, section 50A. Here specifically mentioned, every police officer or other person making any arrest under this code shall forthwith give the information regarding such arrest and place where the arrested person is being held to any of his friends, relatives, or such other person as may be disclosed or nominated by the arrested person for the purpose of giving such information. The police shall inform the arrested person of his right and under subsection 1 as soon as his right is to the police station. An entry of the fact as to who has been informed of the arrested of such person shall be made in a book to be kept in the police station in such form as may
You're
be.
reading which provision?
Section 50A. Forthwith, lordship. Forthwith.
No, subject to.
That means describing.
No, subject to practicability.
My lord, here in this case,
They have to come to the place and then collect their phone number.
that is why,
And
lord.
then,
My lord.
take a photo of the notice and send it. That much practicality has to be given.
My lord, in this case, they have followed 50,
50, but
If-
not 50.
not 50.
Okay.
50?
Fine.
In a visiting.
No, no.
my
So
lord,
that
uh,
Visiting report after 2 months.
they have-
After 2 months, it had to
Then
even.
no, see, the law says like this, that the person something happens, an incident happens, and and the person comes to know, obviously, when a family member does not return home, people will ask what happened, then he got arrested. But the law is not bothered about that aspect, that how the family member came to know, family member might come to know about someone's arrest through media also. But the law says that whoever arrests, he has to inform the arrested person and this. So at that time, these things were not very clear. So they did not know. Many things were not known. So in my opinion, wherever these grounds have been made out and this accused have been granted bail despite some serious nature of the offences, we should not bother much because this is the law laid down by the Honorable Apex Court interpreting constitutional provisions.
Yes.
Constitutional provisions were always there. Section 50 was always there, but this is a new interpretation of existing law, already existing statutory law. And in terms of that, whoever gets the benefit, let them get the benefit. We should not bother. But the most important thing is that, see, this is only bail. Trial should be conducted properly.
Yes.
Trial is still there. And secondly, now, if today the IO does not furnish a notice under 47/48, that will be inexcusable because now I am expected to know. Right? Now you please complete your submission.
When the team visited their home, they found their elder daughter with other sibling were dead. And they have, she confirmed that she has the knowledge of their parents' arrest. And after that, the visiting report was also submitted to the department, which was enclosed in our affidavit, reply of additional.
Let me see that and then I'll dictate.
Reply to.
And one more thing,
Very
my lord,
vital.
in the final offense report, there are some pictures of their elder daughter with other siblings, where her signature were there. I can call them. Was not. That thing.
This is your additional affidavit, right?
Additional affidavit.
No, not.
Additional affidavit visiting you. Answer.
No, bail objection, yes. I want to see
Bail-
the bail objection. No, I'm trying to see your bail objection. Shall see.
This is report.
4 cases of morphine. It's not a joke. It's a very serious, but anyway. They did not know why. They informed the family members.
They
But
inform
then-
on
but they did
22/4,
not know.
2024, or that too even not in writing, lordship. These are, who has received these copies?
Visit reports. What is visit report?
Visit report, but who has received this
No,
copy?
no, what is visit report?
I have no idea, lordship.
Just,
They go to the place,
yes,
their house.
to find a home actually. The place is so isolated, they could not reach it at the times. And after that, they
You know, visit, it was a visit.
No, no.
Oh, no, who has received this?
Here.
Picture to Kannada.
The picture has a weak signature.
But,
Masima.
but whether these persons are witness in this case, my lord, how can they prove that this
her
person
statement,
received?
her-
Her statement, how they can prove? Well, 67 is over by the, by the Supreme Court, lordship, in Tufan Singh case, lordship.
That's anyway, so, okay, completed. Heard, K. Nargis, Learned Counsel. You are good, please.
P.S. Chakraborty.
P.S. Chakraborty, Learned Counsel, Standing Counsel, appearing for the, this is, which department?
DRI.
There.
DRI. Special Public Prosecutor, DRI. Full stop. The two accused petitioners herein, who are husband and wife, have invoked the provisions of section 483 BNSS seeking regular bail in connection with NDPS case number 261 of 2024, arising out of DRI so-and-so case number. Full stop. The case is stated to be pending before the learned additional session just number 3,
Yes.
Kamrup Metro. Full stop. The accused persons were arrested on 3/2/2024, and since then, they are in custody. Full stop. The allegation is about recovery of 4.141 kgs of suspected psychotropic substance morphine from their possession. Full stop. The primary contention of the learned counsel for the petitioner is non-compliance with regard to section 50A CRPC, which stipulates that grounds of arrest have to be furnished to the family member of the accused upon his arrest. Relying on the settled law in this regard, it is contended on behalf of the petitioner that due to such non-compliance, they may be granted bail. The learned special PP, on the other hand, submits that the quantity in question is commercial quantity, and the investigation has collected sufficient incriminating materials against both the accused persons. And it is also submitted that the family members were aware of their arrest. And in this regard has also drawn my attention to the visit report dated visit reports dated 22/4/2024. Next paragraph. Considering the fact that the penal provision of NDPS Act pertaining to commercial quantity has been added, is involved, comma. Therefore, on merits, bail can be granted to the accused herein only if the test of section 37 of the Act is passed in their favor. However, in view of the contention of the petitioner side, if the accused are found entitled to be bailed for procedural infirmity at the time of arrest in terms of the law laid down by the Supreme Court, then perhaps it would not be it would be a futile exercise to go into the merits and decide and adjudicate the test of section 37 of the act. Full stop. I have perused the notice under section 50 CRPC. It reasonably meets the stipulated standards. However, it appears that no notice under 50A CRPC was given to the family member of the accused. And, no such notice came to be placed before the court. In the case of Bihan Kumar, full citation, it has been held and that compliance with section 50 and 50A within bracket section 47, 48 BNSS are mandatory, and that grounds of arrest in reasonable detail and specific to the accused have to be provided to the accused and also his family member or relative or nominated person at the time of at or around the time of arrest. Full stop. In the event of failure to do so, the arrest and subsequent detention of the accused shall be untenable, entitling him to bail. In the instant case also, as the notice under section 50A was not given, therefore the same constitutes a fatal infirmity, procedural infirmity at the time of arrest, violative of Article 22(1) in terms of the settled law within bracket, reference Bihan Kumar, Supra. Accordingly, both the accused persons having been found entitled to bail on those grounds are hereby allowed to go on bail of rupees 75,000 each with a surety of the like amount each to the satisfaction of the concerned learned court, learned additional session just.
Number 3,
Number 3.
Kamrup Metro.
And subject to the following conditions. Number 1, strict conditions. Number 1, they shall not abscond and they shall be available for the trial. They shall not hamper or tamper with evidence. They shall not try to influence or threaten witnesses. Full stop. They shall not misuse their liberty to commit any illegal activities or offences, including any offences of consuming or peddling of narcotic drugs plus psychotropic substances. In case of violation of any or more of the bail conditions, the prosecution would be at liberty to move an appropriate application for cancellation of the bail. The bail petition stands allowed and disposed of.
Obliged.
Next, 67.
67.
Movement learned when starts now. In this case, Mr. Esras was appointed as a matter. Today he is out of station. So if your lordship permits, my lord, I can appear on this behalf.
You can appear on his.
Yes, Lord. Yes. My lord, this is a regular bail application, Lord.
Relative of my friends or family members, my lord. This is one of the plea we have taken in this matter. Though, my lord, I mean also non-compliance of the properly, my lord, section 4.
He was arrested on the same day.
Same day, my lord, same day, on 20th August.
Should I wait for him or dispose it off? No.
My lord.
He Decca Learned Council, assisted by Abdul. Your name, please. Third, I'll give your name. DP Gusam. DP Gusam. Learned additional. Para 2 low. Para 3 low. Para 4 low. Para 5. In the progress of investigation of 6. It is submitted that out of the 4 accused persons named in the FIR, including the present accused, Dash Radu, 3 of them have been enlarged on bail by this court on 13/10/2025. It's to peruse the said order placed before the court. First in DA number 3136 of 2025. The given facts and circumstances, this petitioner is also allowed to go on bail of rupees same 30,000 with 102, same conditions. Return back his disposed of, allowed and disposed of.
Deeply
I'm
obliged.
keeping this, huh? for the
Yes,
moment.
yes, my lord.
I'll-
Lordship.
Hands up. Maybe Bhagel, no? Maybe. We'll resume after lunch.
Yes.
Delivery order. AB 156
No, no, I can get it. No, this one is not ready. Take some time. We are to send ready one. Let it go.
AB 1724.
No, little radius. Bail is allowed. Made absolute. Interim is made absolute. So the DA
BA 3141 of 2025.
or the you are some- Didn't it? This bail is bullseye. This is rejected. This is rejected. And this is doesn't
Bail application 3237.
3237. Sign one. 3237 bail application. This bill is allowed. It's not ready after some time. But 1569 is after some time.
I'm being 22, 23, 24.
Hmm? No check.
84 days, my lord, the petitioner is a lady, my lord. First, only,
Okay, let us fix it tomorrow then.
but then, my lord, 23, my lord, because another case is fixed.
I will not be available on tomorrow.
Some, with you.
You want it on 23? In between there are holidays.
Yes, but one case is fixed already.
Only amicus hearing will take tomorrow. Huh?
My lord, I will not be available on tomorrow. Only on 23rd. I will not be available.
Because otherwise I am not finding sufficient. He's not in the court today. Yeah, amicus part is. It is submitted by learned additional PP that the amicus D. Gogoi, due to some personal difficulty, is not available today. And summaries that perhaps the matter can be fixed tomorrow. It will not take much time. List tomorrow. It will be in the supplementary.
My lord, I will have. thought
No,
that-
your hearing is already complete. You can join online. I'll hear him and then dispose it off. And if something is left, it's stuck, then I'll fix it on 23rd.
My lord.
Otherwise, if your presence is required, if I feel, I'll wait for you, don't worry. And if I think it is not necessary, then I'll dispose it off. Okay?
Item number 3, 63, 64.
63 and 64, my lord. Former BSK 6125, this key order was perfect submitted.
So she submitted now.
But I am relying on judgment, my lord, given in the morning, my lord.
Huh.
Sanjay Chandra, my lord,
Oh, no, it's famous case on bail, no?
lordship,
Sanjay Chandra is a famous case on bail.
paragraph 46.
Paragraph?
46. Cooperate with the trial, my lord.
लिखियो, हाँ? Yeah. This subsequent petition or no? Or
Lordship,
first?
lordship,
Subsequent
earlier rejected.
rejected, no? Yes. When it was rejected? Have you annexed the copy?
Lordship, lordship, page number 30,
Okay.
item number.
Only for facts part I'm saying. Take it from there. এইটো আমাৰ ইয়াৰে page 30, huh? Page 30, you can take it. Now নামটো black. And P Bhattakur, additional PP. Para 2, same, 3, same. And the present accused was arrested on 2/8/2025. And since then in judicial custody. Still. It is submitted by the learned prosecution that instruction has been received that upon completion of that investigation is completed and charge sheet has been submitted, right?
Case number 65.
Right, CS number
65/25, dated 10/10/25.
10/10/25. In the para 6 right, it order, para 6. 40,000 once you read.
Lordship.
Stands allowed and disposed of. I'll give this back to you. Just for a moment, I'm keeping it.
It's 63, 64 also same.
Same.
MPS. Date of arrest is different.
Hmm? Or 63, 64 also same.
Only date of arrest is different.
Oh, date of arrest is different. We do only silent. 3.4. Well, where is it? 63, he was arrested on 8/8/2025. 64.
64 arrested on 2/8.
24/7.
Oh, yes, lordship,
24/7.
lordship, 24/7.
24/7/20. 66, 64.
Oh, bless.
Hearing 35, 36.
63, 64, দুটা।
May I please, your lordship?
Admission. 63 or 64, sorry.
35, 36, lordship. Also, it's a 482 application, lordship. Lordship. 35, 36, my lord. Yes, they receive petitioner in interim, my lord. Interim, my lord. And I have appeared, lordship. My statement have been recorded, lordship. My prayer before lord.
What? Is it? Okay, you take your time. Interim is there, we'll extend it. Same order of, yeah, the 36, 35 and 36, the case diary as called for has been received. However, considering its voluminous nature, spelling syllable, the learned additional PP seek some time to go through it, comma, which is allowed. The interim bail passed on 10/7/2025. Stands extended till the next date of listing. When do you want it?
2810.
28/10.
Compliant.
Diary receipt? Hmm? Fake SC certificate. Hmm?
My lord.
Sorry, Lordship.
No, it's- no, no, no.
Lordship.
No problem.
And Chief the bail application, Lordship, he is on interim, Lordship, he appeared before the IU also, Lordship.
Yes. Don't take tension, relax. You can have a, you should have some facility for water also here. Anyway, so he was granted interim, right?
Lordship.
And the order is there.
And he appeared
So
before the IU.
same caste certificate, 2 cases were filed. And that is the reason it was given. interim. Investigation, what has it revealed?
The allegation is that, my lord, the accused petitioner, my lord, who was, my lord, presently as an assistant professor.
Can you check your microphone? I'm hearing, not hearing properly today. That side. My side is okay, no? Audible. Anyway.
এটা আছে no?
Should be just
My
fine.
lord, here
Don't
the
be
case
loud
is
also.
that, my lord, that is a accused petitioner, who is a, my lord, assistant professor of one of the college, my lord. Earlier occasion, now the case is that, my lord, he, my lord, using his, one of the, my lord, that is the certificate, where he is stated as a, belong to the scheduled caste category and belong to a caste Bonia. Now, my lord, in the meanwhile, my lord, that is the one of the, my lord, member, my lord, who is from the scheduled caste, some associations board. He filed an Ejahar earlier occasion, my lord. That time, my lord, that is the search sheet submitted and my lord discharged at that point of time. During the meantime, my lord, in the, my lord, next phase, my lord, from the office of the deputy commissioner, my lord, one, my lord, report has come out, and as per that, his, my lord, that is the certificate, my lord, which is used, my lord, that was, my lord, cancelled. So it is not, my lord, it is not the original one, or something is there, that was cancelled. Thereafter, again, this, my lord, because now the cause of action arising when, my lord, that a cancellation is made.
Then it was filed.
But this petition is made, and to challenge that cancellation, they have already filed a, my lord, writ before this honorable court, and that writ petition is also pending, my lord. That is from the side of the accused petitioner, challenging that cancellation order passed by the deputy commissioner. And in the meanwhile, this, my lord, this FIR is lodged, my lord. And my lord was pleased to, my lord, earlier occasion, my lord, to grant him interim. And as per the note, my lord, available with the record, my lord, he appeared, my lord. Otherwise, my lord, this investigation, my lord, is in the nascent stage, my lord. Because, my lord, the allegation is serious, because stated, but I didn't, my lord, gave the.
It was, I have written acquittal. This is the same thing, PRC case number 260 of 90.
Yes, yes, sir.
He was discharged.
He was discharged, my lord.
No,
That was an earlier occasion.
No trial, discharged.
Discharged,
No,
my lord.
Lordship, after conclusion of trial, Lordship, after
No,
conclusion of trial.
Discharged.
No, no, after conclusion, I have annexed the order also, Lordship.
Stated as a discharge.
Acquittal order, that is, Lordship.
Oh, this is the judgment.
Yes, yes, Lordship, I have annexed the judgment,
Anyway, whatever it is.
Lordship.
So anyway, for crucial, yeah, according to this copy, it is acquitted. Anyway. So I have, because I don't know, I may have written wrongly also. So now investigation is in initial stage, but he had
Yes.
appeared. These are,
He appeared, man. He appeared, man.
but this is allegation is definitely, these are, no, caste
Yeah.
certificate is.
Yes, my lord.
That is under challenge, Lordship.
So anyway, so. Step into, আমার আগৰ order to first, second, third paragraph, very same. Stop. Sorry, 7th paragraph. Seven paragraph two, seven, paragraph seven.
APA two, APA for
The petitioner was granted interim pre-arrest bail on 8/8/2025 by this court, pursuant to which he stated to have appeared before the IO and his statement recorded. The case diary has been received. It is submitted by Mr. Boyso, learned additional PP, that on earlier occasion, criminal case was filed against the petitioner over the same issue, and it resulted in a criminal prosecution and finally acquittal. So, it is further submitted that as per the materials available in the case diary, the caste certificate of the petitioner was cancelled by the authority, and against which the petitioner has filed a writ petition before this court, and the same is pending. After the cancellation of the caste certificate, this FIR was lodged. The backdrop of the aforesaid facts and circumstances, and also the appearance of the petitioner before the IO, I am of the considered view that the investigation may not be prejudiced if the interim bail is made absolute. Accordingly, the interim bail granted to the order dated so and so is ever made absolute, subject to the condition that he shall not hamper or tamper with evidence, and he shall not try to influence witnesses. Violation of the bail conditions would make the bail liable to be cancelled. Return back the case then.
Obliged, Lord.
very good point. First, May it please Lordship. My lord, update.
Updated case.
Well, update CD has not been received, my lord. Only the statement of the petition number 1 is recorded, my lord.
Well, so far my information is concerned, all of them has appeared and they have recorded their statements. It is regarding, my lord, this non-payment of money, my lord. So your lordship has granted, my lord,
Interim bail is
interim
there.
bail, my lord.
Interim is granted.
Interim has been granted, my lord, and with a direction to appear before the IO and to record statements. And my instruction is, my lord, that they have already appeared.
Let the statements be
My lord.
procured.
My
right?
lord.
No, you
My lord.
bring the statements.
My lord.
Okay. We will keep it pending.
My
So,
lord.
petition number 1 statement is
Statement has
there.
already recorded, my lord.
It
It
is
is there.
recorded, it is in the case diary, my lord, what my learned friend has said.
It is submitted by learned senior counsel, Mr. P. Bora, that as per his instruction, pursuant to grant of interim bail on 11/8/25, all the petitioners appeared before the IO and their statements have been recorded. Mr. G. Chutia, learned counsel, PP, additional PP, on the basis of the case diary receipt, submits that except for petitioner number 1, the statements of the other petitioners are not available in the case diary. So you
My
get
lord.
it, so
My
the case diary may be sent back and procured again with the updated investigation, including the remaining statements of the accused petitions. The interim bail granted by order dated 11/8/2025 stands extended till the next date of listing. List the matter on, then suggest a date.
After 2 weeks, my lord.
Let me give them, 16.
Third.
3/11.
3/11, I have some, but lordship may fix
Next
it.
day, 4, 5.
4, 5.
5 is,
Five is
just to be a
holiday.
holiday.
4,
4.
6, 7, no, my lord,
7.
7 or 8, 7 or 8.
7.
7,
8 is holiday again, 7/11.
7, 7.
7 lies.
May I please, Your Lordship? Lordship, in this case, the petitioner was previously granted interim protection, my lord. And he has appeared before the investigating officer, his statement was recorded. He is fully cooperating, my lord. What happened in this case, my lord? The petitioner is the elected member of ward number 2 of Dhumkura Gaon Panchayat, my lord. And my lord, the informant is the husband of one Pakiza Begum who contested the election from the same ward, and she was defeated by the petitioner, my lord. My lord, after her defeat, just to harass the petitioner, my lord, the husband of the said lady filed this instant FIR. My lord, only because of such political rivalry, my lord. And my lord, kindly see the FIR, my lord, at page 12. Type copy is page 12, my lord. And the allegation against the petitioner, my lord, is that, my lord, the petitioner alleged to have taken just 10,000 rupees from the informant and his wife back in 2015, my lord. But in the meantime, my lord, they neither, my lord, file any FIR nor raise any complaint, my lord. After after a period of 10 years, my lord, they filed this instant FIR, my lord, just to harass the petitioner because of this political rivalry.
What do you say?
Yes, my lord. My lord, here, my lord, that is after, my lord, getting interim, my lord, they appeared and statement recorded. But my lord, here is the case, my lord, where, my lord, the investigating agency filed, my lord, objection for granting of the bail. My lord, allegation is that, my lord, he, with a, my lord, taking some money, my lord, being a ward member of particular, my lord, that is Panchayat, is taking money for making some birth certificate, my lord. He used to help. And, my lord, because he is a ward member, my lord, the police has that apprehension, my lord. He has every possibilities because they are from the locality people. He can, my lord, hamper the evidence and influence the evidence. And the investigation is still, my lord, in the nascent stage, my lord. And he has taken that money, my lord. Many witnesses are examined, my lord. They also say in the same line, my lord. And some, my lord, documents, my lord, regarding the birth certificate also, my lord. That is, my lord, seized by the police, my lord.
My lord.
That is the case, my lord. My lord, may kindly peruse the same, my lord. Otherwise he appeared.
And he was elected in recent last Panchayat election, my lord. Allegation is of, my lord, 2015.
Elected representatives should be even more, conduct should be. Anyway.
Absolutely false allegation, my lord.
No, that's, but the investigation, what does it reveal? Does it indicate false allegations or some materials are there?
So some materials, they have collected some materials apart from them also, my lord. I have, my lord, flag marked those also, my lord. Some, my lord, collected some, my lord, these documents, my lord.
After 15 years, my lord, after 10 years. Will cooperate, my lord, with any stringent condition, my lord.
The last order to first three paragraphs on same. First two paragraphs. The petitioner was granted interim bail on 3/9/2025 by this court, pursuant to which he stated to have appeared before the IO. The case diary as called for has been received along with a bail objection. The learned prosecution submits that investigation is found materials lending support to the allegations about the accused preparing false birth certificates and other public documents from people in exchange for money, the statements of the witnesses also lend support to the said allegation. The IO has submitted a bail objection stating that the petitioner is habitually engaged in preparing and supplying fake birth certificates and other official documents to different persons in the area in exchange for money. The IO has contended that such activities on part of the accused can lead to many illegal activities and acts on the basis of such fake public documents. Stop. In the given facts and circumstances, stop. And considering the fact that investigation is not yet completed, I am of the considered view that this may not be a fit case for grant of anticipatory bail. And accordingly, the bail petition stands rejected at this stage, thereby vacating the interim bail. Return back the case diary. Let investigation proceed. Oblige. 40, 44.
44, 45, 46, 47, 49, 50, that's 14.
All are all are able. And আর একটা তে বলে 14
Element 14 lordship, 1-4.
আমার কি হলো 45 45
along with 14.
45 my lord.
Huh.
These are all government,
Case diary has been given back to you.
Yeah, lordship.
but these are government servant, there was a protection which is granted.
I don't think because I've seen the material.
Yes, my lord, they,
And-
on 9/10/10, for your lordship
Yes, how the
information,
statements have been recorded.
recorded.
I have not
And-
checked whether statement of each of them is recorded.
one
because
of
I was
the-
perusing the case diary from the point of view of the person who was in custody.
Yes, two, the one has been executive engineer has been recorded statement. And so far as other two, they said that whenever is required, we will call you. Pranjal Bharosaji statement has been recorded.
Pranjal
That-
Bharosa's
that
statement
statement is-
statement is recorded.
Recorded. Rest two, they said that whenever it is required, we will call you.
Let me just dispose it of. the
Yes.
Chamber. I'll go through it. and
Yes, yes.
I'll need the CD again.
Lordship. And the item number I have listed it, number is given lordship, already given. Go through it lordship and
And there is a, your lordship just is,
I've seen.
yes, there is a contract which has been your lordship that the interim was considered on that ground. And my statement, whenever is required, these are all governments official. And they said, whenever we went to them, they said, whenever is necessary, we'll again call you. Yes. Deeply obliged.
So far as 44 is concerned, there are four.
The regular bail has been allowed. I have
Yeah, that's
pronounced.
one, yes, my lord, so far is 44 is concerned, my lord. Item number 44, there are 4 persons, my lord. There. So already 1 and 4 was granted interim and their statement has been recorded.
Okay.
Probably that is with the case.
Oh, one has been given. Yes.
1 and
Only
4,
one.
my lord. So, but rest of my lord, your lordship have already gone through the case there and also
Yeah,
everything, my lord, even the last,
This is from the point of view of the person whose bail is there, but still
My
I
lord.
remember some things.
my lord, I did,
Things should
deeply.
be disposed of today only. রেখে থাকো, আজকে করে দিন discuss. তাহলে যেটা সব হয়ে গেল। ইতিহাস-
along with 14 lordship,
along with 14.
14, 1-4.
Huh?
45, 44, 45, 46.
45, 44, 45, 46, 47,
49,
49, 50, along with 14. Well, I have,
1-4.
I have given the numbers to the
Until 20, huh? একেটা ধৰণৰ ধৰ
May it please your lordship, my lord, PRS bill application, FIR paid 10. Relevant portion at page 12. I am not named in the FIR. I was on interim. I am around 64 aged. Only apprehending because some stolen goods. Previously, I used to have a scrap materials shop. That is why I am apprehending.
Something was seized from your place?
No,
Yes,
nothing.
yes.
Nothing.
Charge sheet submitted, sir.
Charge sheet. So CD has not received, no? Only charge sheet.
Charge sheet.
Against him also?
That is not a way that
Not clear.
we
Not
have
clear.
got the message of that
Oh.
in this case, charge sheet is submitted, Lord Chief.
I'm making it absolutely, you cross-check whether he may not have been sent up.
My lord, your lordship, my lord.
তো আমরা আগৰ order টো লিখি দিম, হা? But, learned, এইটো para 5 ৰ পৰা লিখিব. 1 to 4 is same, para 5 of. DP Goswami, learned additional PP submits that as per communication received from the IO, investigation is completed. And it has resulted in a charge sheet. In view of the completion of investigation, the interim bill granted by the order dated 15/9/25 is hereby made absolute, subject to the conditions that the petitioner shall be available for trial if one commences against him, and he shall not hamper or tamper with evidence. Bail petitions then allowed and disposed.
Wait, please, your lordship. Lordship, may kindly find FIR at page 9. lordship.
Which site is it to go down?
Have a statement record to you, sir. Someone is appearing for the informant. This case, no.
No. Question, postpone.
No, not this.
Made of.
So it's not there. No, no.
Allegations are a bit peculiar and serious. Anyway, so
Actual fact, I have narrated paragraph 5, lordship. Paragraph 4, page 4, lordship. Mechanism. Small paragraph. This is the actual fact of the case.
Husband or husband or
okay.
Lordship, here is the CD, my lord, pen drive with the photograph, with the video of that particular woman, my lord. And it was recorded from him and the statement of the.
It was recovered from him.
Him, my lord. And it was, my lord, victim statement and the husband of the victim is also recorded, my lord. And everyone saying with the line of the, my lord, FIR, my lord. That the photo, that video has been viral by the petitioner and that has been, my lord, recovered from him. my lord.
I have also stated, my lord, in paragraph 4, there is a relation between the informant and the petitioner. I have not denied, lordship.
একটুখানি কল করবো ফোন ব্যাক ফোন ব্যাক এখানে কোয়ালিফিকেশন দিয়ে আছে করা ইনক্রিজ
complainant is supported, it seems, allegations.
My lord.
That photograph has been made viral,
My lord.
according to the
that video,
investigation. These are spray.
my lord. And demanding money, my lord, for that also, my lord. That is there. Right, lord. Mm.
Lordship may submit online, Lordship.
Yes.
Lordship, I have admitted that there is a relation between the informant and the petitioner. And the fact I have stated, the lady took some money from me on, when I asked for that money, this was lost, Lordship. And Lordship, as per the report, Lordship, if everything is required, recovered, whether custodial interrogation is necessary, that may be left into Lordship.
It's okay, no problem. But the allegations are quite, materials are there.
Lordship, otherwise I am ready to cooperate.
Difficult, no? This,
I will cooperate.
Regular bail also it was, it would have been different, but AB.
And both of them are.
It is already made, see, just imagine plight of a person if something is,
Those are
the person should be also careful nowadays. But what to do anyway?
They are major, Lordship, well, cooperate in any
First
condition.
take care of. The case has arisen out of an FIR logged by the alleged victim woman. The gist of the allegations is that the accused threatened her and thereafter forced her to communicate with him. But subsequently, he recorded some video calls and with the threat of making them viral, tried to extort money from her. And it is also alleged that as she did not pay the money, he already made the video viral to other people. So Chutia learned additional PP. Submits that case diary has been received and investigation has lent support to the said allegations. One pen drive containing one improper photograph of the informant / victim was recovered from him. And investigation has also shown that that photograph / video was made viral by the persons. It is submitted that the statements of the witnesses lend support to the same. Upon perusing some relevant portions of the CD, I find force in the contention of the additional PP. Investigation is not yet complete. In the said situation, this may not be an appropriate case for granting anticipatory bail, and accordingly, the bail stands rejected. Return back the case diary. Investigation will continue. Mr. Singh?
May please, Your Lordship.
Lordship, case there is not available today.
My lord, on 26/9, it was called for almost 20 days, my lords. My lord is a civil servant, central government employee, my lord. And the only apprehension is on page number
Let the case there come.
31,
It's a
my lord.
Nupur Bora case, Lordship.
Vigilance case, CM vigilance.
CM vigilance case, Nupur Bora case, Lordship.
My
it's a
lord,
high dignity
I'm
case.
not name accused or anywhere in the.
But anyway,
FIR.
just a minute, can you kindly get the CD because naturally he is apprehended,
Lordship, Lordship.
arrest and so, since
No, I have already.
since interim is not there,
Lordship.
so his anxiety is understandable.
Yeah.
When can you get it? Can you get it on Monday or Tuesday? Monday, sorry, Monday, Tuesday, both are holidays.
Holidays.
Holidays, Lordship.
On the reopening day
Reopen.
or on we discuss.
My lord, until then,
Yes.
if I may be protected, my lord, because my
After
apprehension only lies in page
opening
number
lodge.
31.
It's,
Because of PC Act, I'm hesitating to.
23rd, Lordship.
23rd. Kindly get it, huh, on that day. We'll
Lordship.
dispose. Just hold on for a few days.
Yes, definitely,
The
Lordship.
case diary as called for is not yet received. The learned counsel has expressed his.
Wait.
On behalf of the petitioner has expressed his concerns due to delay.
Second, Lordship, our
receipt
name
of
may
the
be
FIR.
shown.
Huh?
Name was not shown there.
The name of the special public prosecutor, CM Vigilance Cell, may be reflected in the cause list. Issue reminder for the case diary fixed on, list on 2310.
20.
Right? On that day, we'll.
All right,
dispose
all
of
right.
it.
But the one thing I have to tell before you want to go. There are some cases fixed today, 31 to 34. The CM Vigilance case diary was well available there. But that those cases I have now heard that those cases have been already been taken adjournment by the petitioner side. But Lordship, we are not aware and was not informed. Lordship.
Not very important. They said.
31 to 34, Lordship. In those cases were not in.
When did we fix it?
The 23rd, 10th of
Yeah.
October, Lordship.
I see.
There is a notification of the Guwahati High Court also, Lordship, in this regard. Very unexpected, Lordship. For
Now,
such a senior advocate.
who mentioned this one? 31, 34? Huh? Senior counsel did us mention.
Yes, Lordship, we are 4 councils here. None of us were informed. And I was well available, Lordship. I think 1 minute or 2 minutes I was late, Lordship. Because case there is there. Because one thing is there, in one case, the bail was rejected.
Okay.
That's my only information I have.
I'm also disappointed.
Yes,
So
Lord.
anyway, so just case diary, you need not.
We'll
send-
retain, we'll retain.
Retain. 23rd, we'll do the.
23rd, we'll
Do the hearing.
We'll do.
Dispose it of.
Obliged, Lordship.
Happily, your lordship.
Lord, FR at page 7, your lordship. It's allegation is that the accused petitioner caught the hand of the victim and touched her body with bad intention.
Seven, no?
My lord, yes, sir.
That Aadhaar matter?
Indeed, your Aadhaar matter.
Manipulation.
So anyway, so it was.
May I go through the chronology once, your lordship?
It's an anticipatory bill. Investigation has not been arrested as yet.
Not yet.
Investigation must have progressed, well,
Indeed, your lordship.
4/8, so almost
Moreover, your lordship, on
2
the,
months.
on the last occasion, some chronological
Up to
sequence was missing, your lordship.
1.5 months, 4/9. 4/10. 2 months or
CD, but CD not yet updated, my lord. CD is only up to 21/7. CD is only up to 21/7/24.
21/7.
21.
There's no, CD was here, was with the police, IO or here, in other places?
My lord,
If it is with the IO, then there is no investigation
yes, no.
after that.
They have not taken back, my lord. We have sent messages for,
It was not taken back.
It was taken back, your lordship, then newly filed and then again came,
It came from the IO only.
came from the.
Just see whether it was taken back just recently.
no, my lord. Since CD is pending here.
Here,
Yes,
in the court.
yes. You have sent messages for taking back, but for updation, but they have not taken back the case.
You should promptly take it back. Prejudices both sides. No? So what will you do? Will you send it back and get it after a week?
Yes, my lord. Next week, my lord.
I will,
with the present status
yes.
investigation. There
Otherwise,
may not be anything more to investigate also.
yes.
Maybe like that also.
Otherwise, I will contact the IO, my lord.
Yes,
and ask
please
him.
explain to him. On the next day, we'll
Indeed.
discuss your part, right? So the case diary has been received, but it is submitted by the prosecution that it is not updated. Case diary may be sent back and procured again with the up-to-date investigation for deciding this bail petition, which was filed subsequently after an earlier rejection on 4/8/2020. For reference. List the matter on,
On my lord, 2910.
is it okay?
2019, indeed, your lordship.
2010. Bail for goal, no? Admission and no. No, admission.
Much obliged to you.
Yeah, I think I should take admission. Councils would like me to take admission.
Right, please, your lordships.
Oh.
My lord, this is a case where the petitioner was an employee of the bank.
Okay.
He was responsible for extending some loan to 9 parties. Now, before my lord senior starts, my lord, I would like to point out one thing, my lord. As per my instruction, my lord, in this case already police has submitted search sheet, my lord. So instruction is there along with the copy of the, so this is
It was filed for quashing an FIR.
yes. Yes, no, my lord, the state or the prosecution cannot play hide and seek, my lord. And status report was asked for by this honorable court on at least 6-7 occasions. They never submitted the status report. Yes, ma'am. Now, one fine evening, they will say charge sheet is filed, that is not fair. This is also status report. But it was never produced before the court.
Okay.
Now, we have filed for,
Earlier order also it is reflected that.
yes,
Charge sheet has been submitted.
several
Last month,
occasions.
So 9/9 it was submitted.
Yes.
So we'll have to look at the charge sheet. Do you have to amend your petition or not necessary?
Not necessarily.
Or file an
Eventually,
additional-
no, my lord, I have filed an additional affidavit.
That will do?
No, to bring on record certain developments, if your lordship would kindly have page number 400, my lord. That's the part of the additional affidavit that reflects the actual position which follows in the present case.
411.
400, yes. It's part of the additional affidavit. Now, for extending this loan, my lord, the purported prosecution was launched. Kindly see. If I have any intention of defrauding anybody, 400. An additional affidavit, it was filed on, Tariq Sharik to Dumalko Nilika.
Help for it, huh? It's okay, I'll find out.
Yes.
Don't worry.
It was filed on 4th of September 2025.
Additional affidavit. This is yours?
Yes, mine.
Additional affidavit should be here, but somehow I am missing it.
Ah.
I'll find it, don't worry. So mainly with regard to the loan, this
Yes,
prosecution.
my
was
lord.
initiated.
Kindly see, I'll just show that this reflects the actual position. This status report was asked from them on several occasions. Therefore, we ourselves filed it, my lord. These are the 9 loanees whose name appeared on the extreme left-hand side, name of the borrower. The loan was sanctioned on this date. Amount sanctions are 2 lakh, only 13 lakhs to serial number 13. Kindly see, my lord, present position in respect of Prakash Kahar, only 42,000 is left. Rahul Sabbar, 40,000. Islam Rahman for 77,000, so and so, so and so. As far as 6 is concerned, it is totally liquidated on 17,425. Then as far as Ashok Koiri is concerned, it was liquidated in 23. Hiralal Gaur, it was liquidated on 26. And as far as Tina Talukdar is concerned, liquidated on 17,323. So out of the 29 lakhs, which was Milord sanction, 30 lakhs 46,000 has been recovered. Now outstanding is only 2 lakh 94,000. So this is the factual position.
Before going further, again, I'm putting my query in a different manner.
Yes.
That since the charge sheet has been filed,
Right.
won't you like to,
I'll bring in record by way of an additional
You
evidence.
have to assail the charge sheet.
Yes,
right?
exactly.
Because I have to look into that also.
Yes.
Right? But broadly, this is the matter. Huh?
This is eventually it boils down to this. Now, as if something wrong was there while, extending the credit facility. Anyway, I'll bring on record the
That's
charge
true.
sheet, that's a different
It's at
aspect.
a stage of admission. Should we admit it? But it will take its own time.
Let it
Proceed for hearing.
remain in the admission column,
Follow itself.
bring on record the charge sheet.
Then after that, we'll try.
Yes.
But actually, it can be admitted, but again, once it, in
Yes.
the regular course hearing may take, I
Yes.
don't know, may take its time. So anything from your side?
Yes, otherwise from the report, because if case is here in this petition, petition is for quashing of the FIR. However, in this case already submitted the
So they have to.
No, merely because charge sheet is filed, FIR can still be challenged. There is no difficulty on that.
Yes. Heard learned senior counsel assisted by A. Ganguly, learned, Ken Chaudhary, assisted by A. Ganguly, learned counsel. Muslim. The application was filed under 482 CRPC as it existed then for quashing the FIR of BIEO PS case number 11 of 2023 under section so. The learned additional PP P. Bothakur submits that in the meantime, a charge sheet has been submitted in the case. Any details of the charge sheet? No, no.
Yes.
In the context of the same, the learned senior counsel for the petitioner submits that an additional affidavit will have to be filed by the petitioner side in the context of the latest development of completion of investigation, resulting in a charge sheet. Full stop. Therefore, the petitioner side is at liberty to file such additional affidavit if so advised.
Different.
The matter, list the matter in the admission column.
After
on
2 weeks, Miller.
2 weeks.
Yes.
Can it be on 6th,
Yes, yes.
6/11?
Yes, yes. Deep reply.
Please go. Yes.
My lordship, the matter may be adjourned for today.
My lord, this matter only your lordship may remember on the last occasion also it had come up before your lordship. Lordship had also reflected that an endeavor may be made to dispose of the matter. Because one thing which has happened here, otherwise because there is no stay, I would not have objected to
No,
it.
it's okay.
But the original
fair.
records have come, my lord.
Hmm?
The case was pending at the stage of defense evidence.
Mhm.
They preferred a revision which was dismissed. This is the second revision which they have preferred. And inadvertently, my lord, the original records of the trial court case have come. So the trial is now not proceeding, my lord. So if they are not agreeable to doing the matter today, may I pray that the registry may be directed to keep a photocopy of the
And send back the.
record and send back the original records. my
There's
lord.
no stay, right?
There's no stay, my lord.
When would you like it to be fixed? Have you discussed with your seniors? When should I fix it? After how long?
Yeah, you can fix any date.
Matter is otherwise, my lord, covered by settled law.
Remembering what is.
This is, my lord, this is a case under the scheme of the NI Act, my lord.
Mhm.
the complainant can adduce his evidence on affidavit.
Yeah.
But the accused cannot adduce his evidence on affidavit because that is settled by Manvi's case. And so now, my lord, they filed the evidence on Manvi Cooperative, my lord. There's 2010 3 SCC 83.
I don't know.
So subsequently, there was another judgment by a co-equal strength of the Honorable Supreme Court, wherein though
Same-
Manvi was
Same
declared
quorum.
same quorum, my lord, and that there's a line there that witnesses to both the parties shall make themselves available for cross-examination as and when called for. So now it is their contention that this term witnesses subsumes within itself also the witnesses for the defense. Whereas Manvi very categorically says that the accused cannot adduce evidence on affidavit, and there are multiple judgments on that point, my lord.
Then
different
same
high
then
courts.
principle which
Yes, my lord.
our division bench had used in the case of this Vihan Kumar.
Vihan
and
Kumar, my
that-
lord. The earlier
Referring to Pranay Sethi.
Pranay Sethi, my lord.
But so the earlier will have to be followed. till
In fact,
December.
there is no conflict as such also because that judgment very clearly deals with Manvi and does not take any divergent view, my lord. So in any case, my lord, let them argue their case, my lord, when it comes up.
Interesting matter. Yeah.
This may be sent off. Original records may be sent back, my lord.
Your good name, please.
H. Basu.
H. Pasu, Learned Counsel, appearing for the petitioner side. He, submits that due to some difficulty of the leading counsel, the matter may be adjourned for the day. Mr. S. Nawaz, Learned Counsel, appearing for the respondent complainant. You were the
Respondent complainant, my lord.
complainant, submits that the proceedings are not under an order of stay, and inadvertently the original TCR has been sent, and submits that perhaps the same will be sent back, keeping a photocopy. I find force in the said contention. The registry shall keep a scan copy of the case record
Of NI case number, my lord?
in this.
No,
record
no,
in
NI
thi-
case number
in this
21
file
of
pertaining to
NI case number 21 of 2019.
NI case number 21 of 2019, and sent back the original case record to the learned court below within bracket CJM Naga,
Additional CGM note.
additional CJM Naga. Full stop. List the matter on. How about fixing it on 6/11?
My lord, the next week if possible, my lord. 11th if possible, my lord. 10th or 11th, my lord. Any date convenient to your lordship. my lord.
10?
Yeah.
10, don't fix it on a motion day if you want.
Yes,
want-
my lord, because this
if
will
you
take
want,
some.
if we try for disposal, keep it on a hearing day,
My lord, 11th then, my lord.
11.
I'm deeply obliged, my lord.
Mr. Goswami?
This petitioner challenges the charge sheet, which is the Annex 3. Your lordship had passed earlier an order. While the scanned copies of the court
yes.
record have come, my lord, the electronic evidence that was not sent, my lord. So your lordship had the
Scan
builder that
copy
has
of
been.
case record has been received. CJM Lakhimpur. You are for the informant complaining?
I am for respondent number 2.
Electronic evidence for deciding this?
For
adjudicating?
deciding, my lord, they have added that section of the trespass, my lord. So it was not a case of trespass. That's what I wanted to, my lord, submit. But other than that, my lord, if your lordship kindly come to page 22, there is Annex 3 the charge sheet. My lord,
If you are aggrieved, your litigant is aggrieved for being charged sheeted, right?
my lord, that is in general, my lord, but otherwise with the addition of this section, my lord, 376, my lord.
He is aggrieved by that also.
Yes,
Not the whole charge sheet.
my lord,
Charge sheet can be quashed in part also, that we know, but he is aggrieved by being
that
sent up for trial. That's what I was asking.
If the 376 goes, my lord, I think, my lord, the risk can be taken. But so far as this, my lord, 447 is concerned, my lord, that electric evidence would have proved, my lord. My client had visited the informant's house. My lord, no, they are cousins, my lord. The husband of the informant. They are cousins.
And there is my lord, relating to ancestral land, there was some differences and disputes was going on. So he had gone there. Now, when he had gone there, the husband was absent, my lord. So wife was there, and ultimately these allegations have been made. So what I wanted to say, my lord, that he had not run away from there. He had come out normally, my lord. It was a normal thing, but later on they had given it a different color. And the medical
came,
evidence is, my lord,
Sorry, your contention is that he went there not with any intention to commit offense.
nothing like that, and he didn't run away.
Anyway,
And then, my lord, so far as 376 is concerned, my lord, there is no medical evidence, my lord, that the charge sheet itself says. Your, page 22, bottom, my lord, if I may read. Yes. Has your lordship got it?
yes.
During investigation, statement of the victim was recorded before the court, and victim was medically examined and collected the medical report. And after going through the medical report, it is seen in the opinion of the doctor hasn't identified any sign of sexual assault. Although the case was registered under section 447, 3765.
In my respectful submission, Your Lordship. And that is why we are before this honorable court, because Your Lordship, this order, there is a new schedule which has been now given, Your Lordship. Again, they have filed a new schedule. Lordship, may kindly peruse the miss case. The new schedule has been now inserted.
Where can I find it?
Page 63 to 72, Your Lordship. This is the miss case they had filed. It starts from page 63. The schedule, Your Lordship, is at page 68. May I read, Your Lordship? The first paragraph.
Page
68. 68, Your Lordship. The accused convicts respondents in order to grab the plot of land measuring 1 katha 10 lesa situated at Lokhara Sarali Betkusi in the right side of National Highway number 37 while moving from Jalukbari Beltola under Revenue Circle Dispur PS Gorsuk in the district of Kamrup Assam and is bounded by North Highway, South Lokhi Tower House, East Sahil Lunthani and West Prabhat Das. Now this was completely absent when they had filed the complaint. Lordship, may kindly peruse the complaint, which is at page 22. We start from page 22, Your Lordship.
Right.
Paragraph 2 only mention paragraph 2, Your Lordship, at page 23. It only mentions about a hotel which is called Sarada Hotel.
But how can a criminal court execute an order like this? Can a criminal court execute?
In
an
my
order?
respectful submission, no, Your Lordship. It has to be, because if they are aggrieved, Your Lordship, they ought to have preferred a suit. They have not done that. And Your Lordship may kindly peruse the judgment of
Was
this.
just for
Yes.
argument's sake, I'm asking.
Yes, sir.
Then was the criminal court wrong in directing that in the judgment itself? That position would be restored.
There is a provision, Your Lordship, that may be allowed. But the
There's
question
a
is,
provision in the.
there is a provision in CRPC, Your Lordship.
Let us see.
Yes, Your Lordship.
Some basic things sometimes you forget.
Yes, Your Lordship.
Then that part is okay.
Yes, Your Lordship, that part is okay.
That part is okay.
That may be allowed, Your Lordship.
Where
If
can
it
you
may.
show me? Because I do not know this actually.
Yes, CRPC, Your Lordship.
In a situation
Yes.
like that, perhaps that can be invoked.
Yes, Your Lordship.
Will it be the provisions pertaining to judgment?
450,
450?
456, Your Lordship, CRPC. 456.
Earlier, no?
Yes, Your Lordship, earlier. 456. The new code, Your Lordship, I will just 456.
And the content will be almost same. So let's
Yes,
see
Your
the
Lordship.
content. 456. Because I'm not familiar with this section. Oh, power to restore. No, I'm not aware of this. I'm not read. Not done any case regarding this. Power to restore possession of immovable property.
Yes, Your Lordship.
Has been dispossessed. Okay, very good. The court rightly passed.
Yes, yes, the court has rightly passed the order, Your Lordship. There is no dispute with respect to that. But the only thing is that there is no schedule mentioned. So without a schedule, it becomes very difficult. And the court, Your Lordship, our High Court, Your Lordship, on the earlier
So
occasion.
the contention from your side is that while such an order can be passed.
Yes, sir.
But when it came to this court, it was said that you dispose of our petition without taking into account the new schedule.
Exactly.
But the learned court below mistakenly went into that new schedule.
Exactly.
This is your contention.
Exactly.
Fine.
And I'm relying on certain Supreme Court judgments also, Your Lordship. Air 2001, Supreme Court 43, paragraph 10. Paragraph 10, Your Lordship.
No, review, yes, review cannot do only clerical errors.
Exactly. Your Lordship. That is the point. Section 10. Will not read, Your Lordship.
You want to read?
Hey, if Your Lordship. Section 362 of the code mandates that no court, when it has signed its judgment or final order disposing of a case, shall alter or review the same except to correct a clerical or arithmetical error. The section is based on the acknowledged principle of law that once a matter is finally disposed of by the court, the suit court, in the absence of a specific statutory provision, becomes functionis officio and is entitled to enter in a fresh prayer for the same relief unless the former order of final disposal is set aside by a court of competent jurisdiction in a manner prescribed by law. The court becomes functus officio the moment the official order disposing of a case is signed. So in my respectful submission, Your Lordship, the learned CJM, Kamrup, has become functus officio in this case, because the order has been signed. Then, Your Lordship, Air 2009 Supreme Court, para 46, page 46, para 18 to 21, the same principle, Your Lordship. The same C62, Your Lordship. Para 21, I will read. Well, I'm relying on paragraph 18 to 21. 21. Section, sorry, Your Lordship, content. As noted herein earlier, section 362 of the code prohibits reopening of a final order except in the cases of clerical or arithmetical errors, such being the position and in view of the express provision in the code itself in the form of 362 exercise of power under section 42, the court cannot be exercised to reopen or alter an order disposing of a petition decided on merits. I have a full bench judgment also, Your Lordship, of Calcutta High Court, 2005 Criminal Law Journal, 3286. This is also with respect to 362, so I will not read, Your Lordship. I'm just relying on paragraph number 47 to 54. Let's say 362 principle, Your Lordship. Then Air 2006 Supreme Court 3051, paragraph 6 to 9, Your Lordship. This is no provision for modification or alteration of judgment.
Okay. So this is
So
just.
exactly, Your Lordship. That's my humble respectful submission, Your Lordship.
Okay, so this, Mr. Islam.
My lord, scan copy was called for, my lord.
It's there, we'll need it for, scan copy is there.
Scan copy is there, my.
Scan copy,
In civil side, there is a judgment, if I'm not mistaken, that if the boundary is not very clear and that boundary is not part of the land, inside land, then that even, and that it can be approximate, dimensions of the land can be identified from the pleadings and other materials, then it can still be executed. But
Exactly,
That
true.
is a civil matter.
Exactly.
But here you're saying that in the complaint case and when the complaint case was being adjudicated, there was no description of any schedule.
Exactly.
But now therefore the schedule cannot be introduced now.
Exactly.
Especially in the context of the High Court's order.
Exactly.
So this is okay. This is law convention. So High Court order is of course clear that without, let us go back to this again before I come with him. That it was at
Wait.
page
81, Your Lordship.
81. This court's order shall proceed with the miscellaneous so and so pending without taking into account new schedule. Yes. And the, okay. New.
My lord, the new schedule was not here, my lord. This is the old schedule. Before filing the complaint case, my lord, there are three numbers of petition was filed. One petition of 107, file number 190 of 2008. Another is miscase, and another 145, 146 was filed, my lord.
Your petition number, you're saying?
My lord.
Petition number?
Petition. There are three petition was filed before filing this complaint case. But hurriedly, that complaint petition was filed without the schedule. And thereafter, my lord filed the petition before the Honorable CGM Court, my lord, that 107 case be in 190, 2008 may be treated as a criminal case, my lord. Then that schedule may be taken in the complaint case, my lord. And in view of that, my lord, that schedule has been used and passed the order by the Honorable CGM Court, my lord. So that schedule is not new.
But the High Court order said that, what is the new schedule? What is the schedule which was submitted?
My lord.
By the petitioner? And I'm asking this question because we have to look at that schedule and to decide whether it is the new schedule, right?
No,
Then only you can apply this High Court's order.
This is not a new schedule, my lord. That Honorable
that is your
Lordship, High Court has passed as order, my lord. In that said, my lord, the new schedule cannot be used, my lord. So, my lord,
according to you, this is not the new schedule.
New schedule. This is the old schedule, my lord. Before filing the complaint case, my lord, there were three numbers of petition were filed, my lord. And in that 107 petition, my lord, schedule was, my lord, there. A plot of land measuring 1 kata 10 lesa is situated at Lokras Ariali, Betkusi, on the right side of.
You're reading from?
Kindly see this. I have filed the petition before the CGM.
It is available here in the PCR. It will be available.
That scan copy is there.
I see from here because you will need it. No, your copy you will need it. Let me see from here.
It is scan copy. Flag mara bote ita tas. And that petition is in the complaint petition is there. The original copy and photocopy were filed, my lord, in the petition last portion, prayer portion, my lord, I was written, my lord, in the complete petition.
No, this was a petition filed under 145. 145 proceeding.
107
and
144 and 145, 146. Three numbers petition were filed, my lord.
Okay. Itu यहाँ का बोले मेरे पास आने. Okay. No, yes, note to transfer, yes. Okay, proceed now.
My lord, in a nutshell, my lord, there is no locus standi to stand before the honorable court. Honorable CJM, my lord, passed the order and judgment and order on 4/6/2010, my lord. And that order still not challenged by the accused petitioner. Thereafter, against that petitioner, my lord, filed the criminal appeal, my lord. And in that appeal, only modified the sentence and imposed the fine, cost and compensation. And directed to the accused to restore the possession within a period of 30 days. Well, that compensation, fine, everything has been paid in the year 2011. And thereafter, my lord, one after another, one bunch of cases has been filed to resisting the immovable property. And in the year, my lord, in the criminal petition 923/2015, my lord, judgment delivered on 31/2017, here only mentioned that new schedule cannot be give by the complainant. And against that, my lord, then I have come the knowledge that there is several schedule in the 107 petition, 145 petition, and 144 petition. That is why paid before the honorable CJM. Then honorable Chief Judicial Magistrate directed me to directed to the complainant to submit the certificate copy. And that is why collected the certificate copy and placed before the honorable Chief Judicial Magistrate, Kamrup. Then directed the Gorsuk Police Station to restore the possession. So there is no any new schedule, my lord. It is the old schedule. Being the convicted accused, my lord, one after another, my lord, petition has been filing and resisting the complainant. That poor people, like, if he is not get the justice, my lord, then we will suffer.
Anyway.
irreparable loss.
This much only, broadly.
My lord.
May I point out one
My
more
lord,
thing, Your Lordship?
Reply. I'll reserve it.
Yes, Your Lordship.
Officer, see properly, to see actually various aspects.
In the complaint, Your Lordship, no DAG number was mentioned. It's very important. The schedule is there, but there has to be at least a DAG number. in the
DAG number
bottom.
is there, my lord. In the second paragraph of the complaint.
Then, Your Lordship,
And in the new schedule, in the schedule of the 107 petition, my lord,
Now, in the complaint, tag number is there.
the DAG number is there. In the para number 2, my lord.
it carries a holding number,
Holding number I've seen.
but no DAG number. Your Lordship.
Then where
And
number
second-
9 and 10, part of there is DAG number, my lord. 22 to 27.
And one more thing, Your Lordship, one more thing I want to point out, Your Lordship, even assuming, Your Lordship, there was a violation of natural justice, principles of natural justice, Your Lordship. The full bench judgment of the Calcutta High Court has made it apparently clear. Please, para 52, Your Lordship, may kindly take up the 2005 Criminal Law Journal 3286. Three bench judgment, Your Lordship, a full bench judgment, Harjit Singh versus State of West Bengal. If it is subsequently found that principles of natural justice is violated, Your Lordship, may kindly peruse page 52, paragraph 52. May I read, Your Lordship? Your Lordship, for the paragraph 52.
Yes.
We have given our NCS consideration to the issue involved while striking a balance between the procedure to be followed, protecting the interests of justice in the light of the valuable right to property and the valuable right of audience. We feel that in the light of the clear dictum of the law, the court cannot review or recall its final order, even in cases where the parties may come up before it, feeling that they have not been heard or they have left out something which, if placed before the court, may have resulted in a different decision, and that the decision arrived in their absence was an impaired finding. Once the court leaves its pen after signature, it cannot put in once again, except of the situations like for the purpose of rectifying a clerical error or critical error. So it becomes very clear, Your Lordship. Completely functus officio, the court becomes functus officio. That's my respectful submission also.
Not so well also today, so I'll not dictate. I'll reserve.
Yes, sir.
Listed by your junior's name.
Ankita Das, Your Lordship, A Das.
A Das. Also heard Darul Islam, learned counsel for the respondent. Prosecution, there is nothing, no, formal party or not? Formal party. The additional learned additional PP was, sorry, represents the state, which is a formal party in this proceeding. Arguments heard, judgment reserved.
Very grateful, Lordship. I'm very grateful.
Clear word. No, take my time. I'll take a 5-minute break. Huh?
My lord. Yes, sir.
Yes.
May I please, Your Lordship? And this petitioner is behind the bar since 129 days, my lord. And there is nothing in the FIR, my lord, but he was present at the scene of occurrence, my lord, when police raided the house of the one of the accused, my lord. And Your Lordship may kindly peruse the FIR, my lord. There is no allegation against the petitioner, my lord. Your Lordship,
I'll just come on. Just give me. Yes. I see the language again. 57. 51. Okay, FIR at
FIR start from, my lord, page 16, my lord. Relevant para regarding petition.
TCR, no? TCR has been received.
Yes, my lord, that is received, my lord. I have gone through the same.
You've gone through.
Page
18.
Page 16, my lord, and page 19 is relevant for petitioner, my lord.
Is 9, para 90.
Second para, Your Lordship may found.
Hmm.
That on the basis of a statement of one of the accused, my lord, Sabul Hussain Loskar, the police raided the house of the one Taramoni Loskar, my lord. That is second paragraph. Before entering the house, I requested to respected persons such and such, my lord. I escaped this, my lord. Again, my lord, before entering into the house, which is under construction and covered with tin independent independent search the body, police personnel and found articles were mentioned in the self-search list. Thereafter, I, along with my staff, I entered the house and found two persons who identified themselves as Taramani Loskar. That is the house of the Taramani Loskar, my lord, and son of such and such, who I and such and such. Motiul Islam is the petitioner, my lord, son of such and such, such and such. Moreover, I have served one notice under section 50 NDPS Act, both the persons and also explained them about their right to be searched in from the magistrate. Go in Hindi and Bengali, they acknowledged and that they understood the contents of the notice and they agreed to be searched by the police team rather than go to magistrate. Also, in the meantime, Shabul Uskan, who actually, my lord, informed the police about the Taramani Loskar, he recognized the face of the Taramani Loskar and accordingly both of them were searched and interrogated. From the possession of the petitioner, there is nothing found, my lord. But in the house of the Taramani Loskar, he was present because he is a auto rickshaw driver, my lord, and he was present there as called by the Taramani Loskar, my lord. Because he was hired, and I have also annexed the documents regarding his e-rickshaw also, my lord. And police did not seek any further, my lord, remand for interrogation at page 24, Your Lordship may found. Under the above facts and circumstances, I therefore pray before your honorable court granting of 5 days of police remand of the arrest accused persons, namely Sabul Hussain, 28 year Fawzur Rahman, such and such, Taramani Loskar, from whose house the petitioner was arrested, my lord, and 3, my lord, absolution Borbuya. But petitioner, police did not seek for his further interrogation, my lord. And my lord, learned session judge forwarded him in the judicial custody, my lord, Your Lordship may page 33, my lord. Order starts from, my lord. Order starts from page 29. That is order passed on 10/6/2025. On that day, petitioner was arrested, my lord.
And he was
Page
directly.
number?
Page starts from 29, my lord. Relevant, my lord, is page 33.
Yeah, 29 I've taken out. It's 32.
33, my lord. On the same day, my lord, they were remanded to the jail custody, my lord, at sixth para, my lord. 6-7 accused persons, namely Soidur Hussain Borgui and Motiul Islam, that is the petitioner, were remanded to the judicial custody till 13/6/2025. Since there is nothing found from his possession, he is not also involved, my lord. But because of he is arrested, he was present there at the house of the Taramani Lashkar, my lord.
And
And
he does not stay in that house. He stays in a different house.
Different house, my lord.
He was present there.
Only present there because he is e-rickshaw puller, my lord. In the morning, here that Taramani Lashkar called him for hiring, my lord.
Okay.
And I have also annexed as a proof, my lord, his e-rickshaw, my lord. That is why in the name of his wife, my lord, page 42, my lord. Your lordship may annex of 5. That is in the name of his wife, my lord, Rusna Begum, who in fact in this bail application got affidavit on behalf of the petitioner, my lord. And next page is his registration certificate of e-rickshaw, my lord. That he purchased it from Sriram Finance, my lord, through finance, my lord. So that fellow is, in fact, my lord, not involved in this entire crime, my lord.
Just a minute. I want to read it again for myself. Please sit down, please. Just break. Then I will come. We'll start again. Motiul Islam. Okay.
Yes, yes, I know. Might issue.
The house was of Taramani Laskar.
Yes, my lord.
Okay, fine. Now you can tell me.
Yes, my lord has already gone through the FIR, my lord. Yes, my lord.
Quite details, so I had to go.
Yes, my lord, very detailed
So,
FIR, my lord, long FIR, but yet, my
on
lord.
the
mo-
basis of the interrogation information and others,
Yes,
they got information and this was, he was led and they came to this
Yes.
house, raided this house,
my lord.
Taramani Laskar.
My lord.
And there, this person was
My
also
lord,
found.
contraband recovered on two stages. First in the my lord Nakasaki,
Naka,
my lord, two vehicles, one truck, another one is a my lord Bolero vehicle. From where my lord, that is a contrabands recovered, Yaba tablet, my lord. That my lord, the quantity is lesser than the later part. From there, my lord, that is when they my lord interrogated, my lord, they said that is that my lord, that is Sebul Lasper revealed that he had delivered to modified cylinder because my lord in the truck there are some cylinder those who were modified and in those cylinders, my lord, from
Okay,
where
okay,
these
okay.
are recovered. The cylinder Taramoni Laskar of Madhurban also. So his name was taken, and from taking that lead, they went to his house, my lord. But my lord, though it is a long FIR, my lord, from mere reading, my lord, it comes that, my lord, they went to the house of the resident of the, my lord, Taramani, where, my lord, the present accused petitioner was very much present, and from there, the recover. But, my lord, from going through the record, my lord, it reveals that it is just, my lord, they made it a very shortly because first they take the lead, they went to the house of the Taramani, where, my lord, that is this person was also present, and from then they have come to know that Taramoni modified those cylinders and those cylinders were kept in the residence of present accused petitioner. All these statements are there, my lord.
In the CD.
My lord, yes, my lord. In the CD, my lord, I have flag mark, my lord. Now, my lord, here the case is that the FIR is dated, my lord, 10/6/2025 and CS dated 21/8/2025, my lord. And my lord, now, my lord, it is in the stage of, my lord, there is this trial, but it is
Trial has started.
trial yet not comments because, my lord, during the time, my lord, period, there is a order, my lord, that is 4/9/2025, my lord. The 4/9/2025 reflect that, my lord, he was arrested, my lord. He was taken from the judicial custody to another case in Bengal, present accused petitioner. Because of that, my lord, it is not, my lord, progressing, my lord. So, my lord,
That I don't know, my lord, about this.
my lord, may I kindly peruse the, my lord, that is the record, my lord, that is the scanned copy of the record, my lord. I have flag marked all the relevant parts, my lord. So, my lord, at this stage, my lord, yet not, my lord, the charges yet not framed, my lord.
Now, is 37 applicable? 37.
My lord, 37, because, my lord, it is from the conscious possession of the, my lord, present accused petitioner. 1 lakhs, my lord, Yawa tablets, which was recovered, my lord. This is
From, no, from the house of Taramani Laskar.
not Taramani
Yes,
Laskar.
my lord, in the FIR itself is reading.
From, my lord, that is the Taramoni's Laskar, my lord, he was, my lord, found, but, my lord, it was recovered from the house of the present accused
Motiul
petitioner.
Islam.
Yes, my lord. Both their statements are there.
That-
Taramoni
they are,
and both their statements are there.
That means their FIR itself incorrect, my lord.
My lord,
In the
FIR is
FIR,
not the
written
encyclopedia,
this-
my lord. My lord, if all details things it cannot be, my lord, that is the police can write in the FIR. Already it is a detailed FIR, my lord. From the Nakasaki to this point, my lord, may not be there, my lord. That is a settled position of law. My learned friend is very much aware about the date, my lord. So then he can go through the, my lord, that is search it, where it is stated, my lord.
My lord, in fact, my lord, my humble submission is that, my lord, I have already shown your lordship, page 19, my lord, page 19, from there 2 cylinders were recovered from the house of that Taramani Laskar, my lord. And Taramani Laskar's house was searched on the confession made by one Sebul Laskar, that is driver of the truck, my lord. And here the Motul, the present petitioner is there, present there, my lord.
No, that is the thing we have to determine, that as per his contention, that he was at the wrong place at the wrong time. Is it a case of
Maybe.
like that?
My lord.
That
my-
is
my-
his
my lord,
contention,
by
that he
going
is
through
at the
the-
wrong
by-
place at the wrong time.
Yes, my lord. By going through the FIR, my lord, that is the same, my lord, assumption I did made, my lord.
But in
But
the
after
materials-
going through the, my lord, that is the TCR, my lord, scan TCR, which is available with us, my lord.
Two modified cylinders are found in the house of Motul also.
No, my lord, that is
No.
Taramani Loskar's house.
My lord, may kindly see the, my lord, that is the flag marking. May I, my lord, Dada, eto dile মই অকমান দেখাই দিম, সেই statement দুটা, Caesar witness and the statement of this.
No, he was found, I have seen the statements, he was.
No, he was found, my lord, later part some statements are
Okay,
there.
Please kindly.
I have already flag marked all those.
37 determination is a
And-
very, important thing because.
Another thing, my lord, trial is to be started, my lord, and he
With
has
all
already
respects,
behind the bar
uh,
129 days.
Those
Dada,
aspects.
flag point what
So
dada
that
দিয়ে-
part your lordship may
তিনিটা
kindly
flag point
consider.
দিছো, তিনিটাই দিয়ক, মই উলিয়াই দি আছো relevant part. Flag যিকেইটাত লগাই থোৱা আছে সেইকেইটা দিয়ক। Dada.
And another thing, my lord, as submitted my learned friend, that he is again arrested in another case. I don't know about this, but he is in the police custody. If your lordship release him from this case, my lord, he will be automatically there also.
Let me see. Prosecutor.
কোনটোলৈ কৈ দিয়ক। পাৰিব, কিয় নোৱাৰিব?
Orders are different, only orders বাকি আছে। orders 3 বাকি আছে ন? তাই কি নহয় বেছি আছে, 1 2 3 4 সেইটো আছে সাবমিট অর্ডার নাই নেকি?
কোনটো চোৱা চোৱা নাই।
হিয়াৰিং এটা দিছে ন? কেনেকে হ'ব? এইটো এই চাৰিটা।
দেখিছেনে? ক'ত ৰাখি থৈছিল? সেইকাৰণে লৈছিল। মতি বহুত থৈ দিছে। গম পাইছো কথা। His involvement আমি লিংকটো ক'ত খাই?
Which statement?
My lord, I have flag mark, my lord, both the statements, my lord. That is the Taramani, and again, my lord, that is the. সেইটো Taramani.
That statement, my lord, from Taramani, I think, my lord.
Yes.
So he has to save himself.
According to this statement, they went into the house of Motiul Islam.
No, my lord.
No, this
They
statement.
went to the house. of
Sunil
my-
Lal Roy, this witness,
My lord.
says that the police entered the house of Motiul Islam. You have flagged this part.
My lord.
This statement, can you have a look? Can you have a look at what marks? Other parts of the CD is there.
Yes, my lord.
It is here.
Yes, my lord. Here, my lord. There's one part and one part, my
You
lord.
see the portion I have marked by pencil, and in the meantime, I'll see this.
Yes, my lord. Yes, it was a witness. It was an independent witness, independent witness. That was when the address of the rest of the was there. Two people. Definition of the time and notice that the police told us the search procedure and to search the police part. We entered the house and the police found two persons inside the dwelling house identified Taramani Loskar with years and this. As a movie of Taramani heard the public. Yes, my lord. My learned friend also goes through that. Yes, my lord. That is also one of the white witness.
There is some house of Taramani Motiul is.
My lord, here, my lord, the thing is that in some, my lord, they stated, my lord, that is the house of, in some witnesses, my lord, they stated the house of, my lord, my lord, in some, my lord, it is stated as a, my lord, I have sent, my lord, another one, my lord, that is with flag mark right now, my lord.
Like this.
Yes, my lord.
She's a witness.
Yes, she's a witness, my lord.
Taramani Laskar.
Taramani Loskar. Their name is Taramani. Taramani stated, my lord, Taramani's statement is like that. I take the cylinders to my friend's house, namely Motiul Islam. So that is the link, man. I take the cylinders, that is the modified cylinders, my lord, to my friend's house, namely Motiul Islam. Now, my lord, the apprehended person in the first stage, my lord, in the first instance, those who were apprehended, they have taken the name of my lord, Taramani. They said the Taramani, my lord.
Yes, my lord.
My lord, take the lead. They were taken, they said that this is Taramani. Along with Taramani, my lord, that is the Motiul is there. From the, my lord, that is the statement, my lord, he said that it is in, my lord, he, my lord, kept the cylinder in the house of Motiul, my lord. Same is, my lord, in the Motiul also said that, my lord, that I have to say that on 9/6/2025.
Motiul statement.
Motiul statement.
That will not be admissible, but he has said that he doing business.
Same way in both
he's
their
doing business,
statement.
but the
And
statement
my
of
lord,
the statement of what is that witness? Who said that I gave it to two cylinders? you
Yes,
gave
my
it to- In that case, it will be difficult, otherwise.
yes, my lord, that is Sunilal, my lord,
Sunilal, he is one of the witness, my lord.
one of the witness.
And in the FIR, my lord, his name is also there, page 19, my lord. The police have also stated his name, my lord. Chunilal name, one Chunilal Roy.
Yes, see, the thing is that actually 37, we should proceed like this, in my opinion.
My
Just identify the materials with regard to this person
My lord,
who's seeking bail.
my lord.
Take out the materials. We should also write like that. Take out the materials and then see the materials whether on the basis of which
My lord,
we can say or not say that he
My
is
lord.
guilty or not guilty.
my lord.
So suppose since investigation is completed, if the only materials are the statements of co-accused, then it may not be sufficient for conviction. Then maybe we can say that he would not be guilty. Very peculiar thing to say when charge has been framed.
My
I mean,
lord.
charge has been framed in this case.
Well, no, not him, because my lord, he is arrested in another case, my lord. 49, my lord.
That I don't know even, my lord, and I am praying for bail in this case, my lord.
That is, my lord, 4925, my lord. And my lord, here, my lord, there is the search sheet, my lord, file, my lord. And in the search sheet, my lord, there are, my lord, witnesses, my lord, accuser there, my lord, the 5 numbers of accused, my lord. Motiul, Taramani, Afzal Ras, Soidur Hussain, and Sabiul Hussain. And these witnesses, he is a witness, my lord. He is not an accused person. Who? Who, my lord, stated.
Oh,
it
so
is
then
the
it will
house.
do.
Yes, my lord.
Then it will do.
He is a.
What
my
is
lord,
the name of that witness? What is the name of that witness?
That Chunilal Roy, my lord.
Sunil, yeah, that's what I was reading.
He is page 19 in the FIR, his name is also there. He is along with the police party who searched the house of the.
He's an accused or he's a witness?
No, my lord, he is a witness, my lord.
The
Local
charge sheet,
witness.
charge sheet,
No, my lord, he is not an accused, my lord.
he's a witness.
He
Witness,
is
my lord.
witness, my lord.
He's an independent witness.
Then it will do.
He went to the house of the Taramoni, my lord, at page 19, your lordship may found it. Before entering the house, I requested two respected persons of the locality, namely Chunilal Roy
Sunilal is a Caesar witness.
and secondly Shamsul Islam Borbuya such and such, to appear as independent and explain them our purpose of conducting the operation and also serve notices to them. Accordingly, they agreed for the same. Before entering into the house, which is under construction and covered with tin, independent witnesses searched the body, police personnel, and found articles were mentioned in self-search list. Thereafter, I, along with my staff, entered the house, found two persons who identified themselves as Taramuni Loskor 52, son of such and such, and my lord Matiul Islam, that is the petitioner, my lord. Moreover, I have served one notice under section 50 NDPS Act 1985 to both the persons and also explained them about their right to be searched in front of a magistrate going in Hindi and Bengali. They acknowledged that they understood the contents of the notice and agrees to be searched by the police team rather than go to magistrate. Also, in the meantime, Sabiul Islam, who is the accused, my lord, police arrested him earlier. And on his versions, my lord, police searched the house of the Taramani. Sabiul recognizes the face of Taramani Loskor. That it is clear, my lord.
Okay.
At the time of search of such Taramani's house, my lord, independent witness Chunilal Roy and another Samsul Islam Borbuya is present there, where they have found the Taramani Loskor as well as Motiul Islam, that is the petitioner. And petitioner is behind the bar, my lord, since 129 days, my lord. Your lordship may also, trial may start sometime, my lord. So in the.
No, leave aside 37 and then it is very easy to decide this matter.
My
Very
lord,
easy.
my lord.
Automatically, you need
My
not
lord.
go into merits. 1 year
My lord.
charge has not been framed,
My lord,
go on bail.
my lord.
Things that this determination, as I said, first we have to take out these materials. Therefore, only independent witnesses we have to see.
Yes, my lord. Sunilal is the
Sunilal.
witness.
Only one.
Only one man.
Another witness is also there, my lord, that is Shamsul.
He is an accused, Samson.
No, my lord, he is independent. At base.
Sunilal has stated about Motiul's house.
Motiul's house.
Give me some time. I'll just go through. বাকিগুলো matters একজনের করে বলি। নহব, don't pass it. You can please sit down. Don't strain
Madam.
yourself. Don't strain your tired legs. This aspect is very important because
My lord.
think of a situation, you know,
My lord.
that you, me
My-
or him go to someone's house.
Yes,
Suppose
man, that's true, man.
he may have drugs, how will I know?
My lord.
Suppose
My lord, that's
if
true.
there's a raid, that's why I said, na,
Yes, man.
being at the wrong place at the wrong time.
Yes, man.
Suppose
That's
this is
true.
a raid and a person is found with drugs and I am also implicated.
Yes, man.
And though I have nothing, suppose
My lord.
if that is the situation, it will be very unfair,
My lord.
very, very unfair.
My
right?
lord.
So,
My lord.
so therefore, in a situation like this,
My-
always you have to see very carefully.
My lord.
Because he is not resident of that house.
My lord.
They do not stay
My
together.
lord.
They do not stay together.
My lord.
Right?
My lord, we have to
So
see the
that
states map
aspect
also
has
in
to
this.
be very carefully seen, actually.
Because my lord, whether my lord, they are my lord staying in the house, whether my lord it is the house of the motiul or he is in the rented premise, these things may be there, my lord. Because for that reason, my lord, we have to go more in detail. my
Case map is there.
Case map, I didn't get, my lord. Whether again I have to look, it may be there, it may not come to my
I've gone
notice.
through
my
it
lord.
thoroughly, actually. But from the FIR and other allegations, it appears that the raid was in the house of Taramani Laskar.
Yes, ma'am.
Yes, but
Yes,
one witness, Shunil Lal. Shunil Lal, no?
Yes, my lord.
Even in the forwarding report also, police have stated about the Taramani.
এটুকুকে ঠিকই আছে তার মধ্যে কি আছে ঠিক আছে এটুকুকে তো কোনো ডিসপিউট নেই না আরামনিয়ে কাট দিছে সেইটো মানে মেবি করে সেইটো পইণ্টলৈকে আমাৰ ডিসপিউটে নাই তাৰ আৰামনিয়ে
This Samsul Islam Borbia has also said Taramani, Motul Islam, inside the house of, entered the house of Motul Islam. Yeah, you're very right, actually. Case map is necessary.
My
Case map. Case map is necessary. It's not here, case map.
well, I didn't notice my lord maybe there my lord
3 minutes.
maybe there my lord
That's why sometimes original CD is very easy. no?
yes my lord
Suppose
yes my lord
while scanning,
Yes, ma'am.
something is left. So it's case map doesn't. Should we keep it pending?
My lord.
Well,
Your
that can-
honor,
and my lord
incomplete.
one thing is there my lord that
Because
is my
if
lord
the-
ticket order
because,
is not there
This, if the witnesses mistakenly said
my lord
said
My-
that this is the house of Motiul,
my lord
by mistake he has said,
my lord
you know, and
but
all
they
the
are my
other-
lord the local people
Huh?
who are the witnesses
Local people.
These are witnesses they are the local people my lord because my
And
lord
the others have said, and the police has said that it's house of
my lord
Taramani
my
Laskar.
lord
Both
what
to be
my
house-
understanding is that my lord up to Taramani there is no dispute because my
No
lord
dispute.
it is a case of my lord peddlers my lord
At
So where my lord, they know one point is that is Taramani and they said that that is the implication of Taramani from that point, no dispute, my lord. Now, my lord, when my lord raided, my lord, raid started, my lord, 2 persons were found. One Taramani, another one is the present accused petitioner. Now, my lord, two questions come out. But my lord has already, my lord stated. The one is the wrong, at the wrong time or wrong place. My lord, that is the question. That is another thing. But my lord, the secondly, who are the persons, my lord? There is the Caesar witnesses. They are the local people, my lord. After my lord, because
These two witnesses.
yes, my lord. When, my lord, it is
this-
stated there that
who's-
thereafter.
One is this Shunil Lal and
Shunil Lal.
another is
My lord, that is.
Samsul Islam Borbia.
he is also a local.
Yes,
Local.
My lord, one thing your lordship may kindly appreciate that both of accused house in the same area, my lord. That is in
No,
the.
that's why I said, he's very right, sketch map should.
Sketch map.
That's why they draw the sketch.
Yes,
map.
my lord, Pani Tanki, his house is there and Pani Tanki, Betukandi is the same place, my lord.
It is worth spending, some, this time
My lord.
on, this thing, so that,
Because
you
here,
can
my
try
lord,
to do justice at least.
yes,
My
my
lord.
If 37 is, if there are materials against him, learned council will also agree.
Yes,
If
ma'am.
37 is passed, our hands are tied.
Yes,
Then
ma'am.
21 will be invoked after some time, not now.
Not now, my lord, not now.
Mm.
And because, my lord, now, my lord.
As per this Najib, that said that otherwise how will he, within a few months, a person may claim that
Yes,
trial
ma'am.
has not started and.
Yes,
he will
ma'am.
be given,
Yes, ma'am.
My lord.
And even, my lord, right now, we don't have that order, that on what basis, my lord, on 4/9/2025, the order where it is passed. But what nature of that particular case where, my lord, from the jail custody, he was taken to West Bengal, my lord. Now he was in the remand, my lord. What sort of case? If it is a case of, may not be there, we cannot make any hypothesis right now. But if it is a case of, my lord, related to same commercial quantity in the state of West Bengal, then also, my lord, the story is something different, my lord. But that is not very clear, my lord.
Your
Regarding,
lordship may, to ascertain all this, my lord, your lordship may, fresh, LCR copy.
LCR করতে তো
বা
আমার sketch map তো sir,
Sketch map to আৰু হেৰিটো, এইটো টিপি দিব আপুনি।
4/9.
Heard, so learned counsel, who addresses arguments at length on the bail matter. And on the issue of whether the rigors of section 37 NDPS Act is passed or not in favor of the accused. Stuff. I also heard learned additional people, K. Bosso, stuff. However, the hearing is not concluded. The matter may be kept as part heard. And the learned the prosecution cell also, can you, what should I say? The copy of the sketch map.
my lord, because now it is available in the, my lord, learned, my lord,
Court,
this is the special judge court, my lord, court of the special judge. From there, my lord,
That
that
we call for the original CD.
or that can also be called, or, my lord, they can send it, my lord, if, my lord, through, my lord, there is a scan copy of that. If,
Scan copy of the
Scan of this CD, my lord.
my lord,
CD is here.
CD is here, my lord, there is a sketch map available and these things. Or, my lord, the entire CD also they
Entire
can
CD.
send.
Hmm?
Original CD also they can
Yeah.
send.
Mm. The.
Or, my lord, whether, my lord, regarding this order, my lord, on 4/9/25, my lord, whether, my lord, in which case, my lord, he is arrested, my lord. Court can say that, my lord. One order, my lord, I have flag mark, my lord, horizontally flag mark 4/9/25, my lord.
495.
Four-
In this bail petition,
My lord, in the record, my lord,
in the record.
in the record, my lord,
Very well.
in the record. লিখিত আছে 4/9/25, so from
He was
horizon.
taken to West Bengal.
My lord, 4/9/25 order, my lord, may kindly produce that order. Horizontal flag mark, I think, my lord, it is a.
The learned additional PP has drawn attention of the court to order dated 4/9/25, passed in the NDPS case number 78 of 25. Dash, which indicates that the accused Motiul Islam was taken to Siliguri in West Bengal in connection with another case, but the details are not available. Full stop. The learned trial court may send a scanned copy of the fresh scan copy.
My lord,
Scan
scan
copy of
copy
the-
they can send, or only that
Scan copy
particular
of the sketch map.
scan copy of the
Sketch map, if available in the original case diary.
case diary. And along with, my lord, if they have, my lord.
Remand
my
order.
lord,
Further, any details regarding the case of West Bengal,
Yes, my lord.
where the accused Motiul Islam herein is stated to be in custody, may also be provided.
My lord, my lord.
This is the matter on so and so. As part.
My lord, it may be as part are treated
It
as.
will be part.
Partner.
Otherwise, all your effort will be wasted.
My lord.
My lord, my lord.
It took case. Judgment skill during the, it took case.
It may be in the month of, my lord.
Just a minute. I will list the matter on, when should I fix it?
My lord, because things have to come.
First week of November, I won't be there.
My lord.
I'll go to Itanagar. It may get extended by another week also.
My lord.
When do you suggest? 28th,
28th of this month.
will
my
it
lord.
come? No, no,
I think my lord, 28th.
holidays in between.
28th আহিব, নাহিব।
18th.
18th of
He's
November.
in custody, that's the only problem.
My lord.
Will it be late for you? 18th?
80.
Hi,
No,
lord.
no, I would have fixed it in five because I'll not be, because I'll have to take it, no?
My
So
lord.
it will not be, I'll not be available, no?
My
lord.
For
my
4
lord.
weeks.
On 18th, my lord. Oblige, my lord.
Orders are left, no? Orders, what should you do? I'm tired also. But the time is up, so. What were these matters? Can you?
Interim order is there in item 55, my lord. It may continue, my lord.
W-
Here we have taken steps, my lord, by registered AD, but service is not complete. On respondent number 2.
Item
Paucity of time, not
Lot.
reached. 54. Interim
55,
order,
my lord.
granted by the order dated so and so. Shall continues, 55.
55.
55. Interim order granted by the order shall extended till the next date of listing.
Lordship, in item number 56.
Mhm.
In item number 56, let it be fixed on 27th.
28.
28.
My lord, let it be after 5th of November, my lord. It's a senior counsel will appear, my lord.
Lordship, there is a,
56 paucity of time. This is the matter on when, 5th of November,
After 5th, any date, my lord.
Lordship, there is an interim order operating, that's,
interim order.
yes, Lordship.
Interim order will have to be continued.
No, my lord,
But Lordship, there is some urgency, Lordship, so could it be before?
Lordship, may
5th?
fix a date after 5th, my lord, any date, my lord. Let it be on 7th.
No, I can fix it, but you have seen the
Yes,
state
my
of,
lord, that is the.
no, still we cannot manage.
let it be on 6th, Lordship,
In the admission column, Lordship.
admission column.
No, this is for order, it has come for orders.
Now.
Now it will have to
It
be-
have come to the admission.
This
column.
is-
But there is no office note with regard to service, my lord. Respondent number 3, notice issued, but there is no.
No,
office note
I'm
with-
appearing for the respondent number 3. Lordship, I'm appearing for the respondent number 3. My name is not reflected in the.
The name of the learned counsel for respondent number 2.
3.
It may be reflected. Full stop. Interim order shall continue till the next date
My
of.
lord,
listing.
interim order is there, my lord. It may not require extension, my lord.
It is
He-
there till disposal.
Yeah, he is allowed to remain on bail.
An
That
investigation is going on.
Investigation is going.
No issues. So this is the matter on, you suggest, whatever.
Lordship, on 6th, Lordship,
611.
Lordship, they filed, the petitioner has filed an additional affidavit that has not come on record. Lordship.
Additional affidavit will be brought on record.
Lordship, CD is there, Lordship, it may be called again, CD is
Up to date case.
up to date case diary. ma'am.
The case diary may be returned and sent back and procured again in an updated form.
Lordship.
May it please your lordship.
Oblige.
Lordship, with regard to item number 57, lordship.
Mhm.
This I is for suspension of sentence, lordship.
Bail.
7 years imprisonment, lordship. Can it be on 31st of October, lordship?
I can fix it.
Lordship, 31st of October, lordship.
Paucity of time, list on 3110.
Lordship, item number 57, lordship.
3110.
54.
Oblige your lordship.
My lordship, 54 may be fixed needed. 54.
54. What are these matters? Repeat criminal.
There is no interim order. 54.
List the paucity of time. When do you want it? Madam?
Any date, my lordship. There is service in respect of respondent, service is awaited, my lordship.
Is it
Yeah.
awaited?
Yeah, awaited in respect of 6 and 7. In the meantime,
Service report is awaited, stated to be awaited with regard to respond number 6 and 7.
I am for the state respondents, lordship, in this.
Before, no interim order. huh?
no interim order, honorable court is directed to obtain them instruction.
The whole prosecution
Yes, my lord.
regarding service.
regarding service matter, respondent number 3 and 4. So some illegal investigation is
File to because I don't have the file, no, so don't know the context.
Lordship, I have received
6
instruction.
and 7, 6 and 7.
6, 7, 7 awaited.
Awaited, yes.
Yeah, awaited.
You, they should take instruction regarding 6 and 7.
But in instruction is obtain, directed to obtain the government advocate.
Lordship, I have received instruction.
Three
I'll
and
file
four,
it in
my-
the form of
three and
affidavit,
four.
Lordship.
They have already, let them file affidavit, my lordship, they have received news.
They may file. Some of these petitions can be filed as. Are you seeking judicial review? Otherwise, it can be filed for quashing also, just under 482 also. Anyway, list the matter on 411. 411.
Made please, your lordship. Lordship, with regard to item number 58, lordship, there is a interim order till today, lordship, that may be,
It's for hearing.
yes, lordship. My learned friend is there, lordship. Actually, I am for the petition and says for it.
The paucity of time will not be taken. The interim order granted by order dated so and so stands extended till the next date of hearing.
Can it be on 19?
Till the next date of listing.
Lordship, my friend is suggesting in the month of December, first
First
week,
week,
lordship. Let it be on,
Let
9th of
List the
December.
matter on 9/12. 9/12
All lordship, all can be in the first week of December.
Yeah, first week of December, 9/12. Sorry.
Actually, lordship, between the same parties, one appeal is also pending before the division bench, lordship. We might have to wait for the outcome of that appeal.
9, let us fix it for the timing on 9.
Yes, lordship. Till then, interim order may be continued. Please, your lordship.
May I please, Your Honor? Item number 59, Your Honor, delivery of order.
That is, I have not ready actually this. We will have to fix it at another day, it seems. I was looking at the file, but I did not get time. So, কি করবো লাগবে? Huh? Kali. That's most probably I'll fix it tomorrow.
Highly obliged.
Okay.